Of the regular February 2018 meeting of the Tennessee Real Estate Commission. Ms. Maxwell, do you want to call the roll? We can establish a quorum.
Commissioner Gary Bloom.
Here.
Commissioner Fontaine Taylor.
Here.
Commissioner Johnny Horn.
Here.
Commissioner Diane Hills.
Here.
Commissioner Marcia Franks.
Here.
Commissioner Rick Douglas.
Here.
Commissioner Bobby Wood. Commissioner Austin McMullen. Chairman John Grease. You have a quorum.
We have a formal hearing set for this morning. Is everybody here that needs to be here for that? Okay. Well, at this time, I will turn it over to our judge, Judge Stovall. Good morning.
Thank you, Mr. McMillan. All right, if we are ready to proceed, this is a hearing before the Tennessee Real Estate Commission to consider the matter of Van McCormick as a result of the notice of hearing and charges filed in this matter on September the 20th of 2017. My name is Tom Stovall, and I've been assigned by the Secretary of State to be the administrative judge at this hearing. As the administrative judge, I will not participate in the decision that is made on the merits of this case. That decision will be made by the members of the board that are present this morning and have just been identified for the record. However, I will make all rulings of evidence, law, and procedure under the authority granted me by the Tennessee Administrative Procedures Act. The members of the commission are instructed that their decision in this matter must be based only upon the record that's produced during the course of this hearing today. Failure to abide by this instruction could result in the matter being reversed or remanded back to the commission for further consideration should it be appealed to transfer court. I'd also ask the commissioners at this time if any member of the commission has received any ex parte communication concerning this matter or has any prior knowledge of the allegations or familiarity with the respondent, Mr. McCormick, in this case, and if so, put that on the record at this time. All right. Ms. Robin Ryan of the Office of General Counsel represents the state in this matter. Mr. McCormick is present this morning, represented by counsel, Ms. Susan Palmer of the Nashville Bar.
Your Honor, isn't it supposed to be recorded?
It is.
It is being.
Yes, it is.
I pardon you.
I thought there was not recording.
I'm sorry? Oh,
I thought, okay.
are we good? Okay.
Yes, sorry.
All right. The record in this case at this time consists of the notice of hearing and charges, which I previously referenced, which I will pass out to the commission in a moment. Also, the hearing, this matter was originally scheduled for a hearing on November the 9th of 2017, but by agreement of the parties, it was continued into today's date. I also have a witness and exhibit list filed by both counsel in this case. At this time, I'm going to pass a copy of the notice of hearing and charges to the commissioners, and we will stand in recess for a moment to allow you to review this document. It's not very long, and when everybody has read it, just let me know and we'll continue. All right, has everybody had an opportunity to review this? All right. Ms. Palmer has one witness in addition to the respondent. Ms. Ryan, did you want to call for the rule?
Probably, yes.
All right. Could you ask that of the gentleman to step out, please? All right, Ms. Ryan, did we have any, or Ms. Palmer, any preliminary matters we need to take up, or are we ready for opening statements?
I'm ready.
All right, Ms. Ryan, if you want to remain seated because of your...
Thank you. Please forgive me for remaining seated. Next time you see me, I'll be on my 2, I believe. This matter is here today on the issue of the failure to supervise by this particular respondent. The proof will show that Mr. McCormick, who is the respondent, was at all times a licensed principal broker with his business Van McCormick Realty and Auctions. The actions today occurred in 2016 and involved a purchase and sale agreement for a property located on 5607 Scenic Drive in Old Hickory, Tennessee. The evidence will show that this property transaction was handled by an affiliate of respondent Lee Hall. Mr. Hall, you will learn, represented the buyers for this property, and the owner, now the owner's agent, was not made aware that the sale of that home was contingent on the sale of the home of the buyers, and those buyers were represented by Mr. Hall. As a result, closing was pushed several times, and in the meantime, the owner had already moved. This mistake was huge, and why the affiliate is the one who made the mistake. We believe this respondent had a responsibility to make sure that such a mistake did not take place. You will learn there was no discussion, apparently no internal office checklist either. As a result, Mr. Hall did sign a consent order and pay the penalties for that consent order, but the issue here today is this respondent's failure to supervise the work activities of Mr. Hall, and for that error we are asking that he be charged a civil penalty and that be required to pay all court costs in this matter.
Ryan, Ms. Palmer, I'll extend the same courtesy. You can stand or if you can sit. Either one you want to do.
Good morning, everyone. First, let me say it's my first time before the Commission, and I'm honored to be here. Forgive my procedural snafus, but thank you for your time. Everything that Ms. Ryan said from a factual perspective is correct. Mr. Hall, the agent in question, did represent the buyer in this case. The buyer made an offer on a property. He did include a contingency to sell his home, which had a purchaser and was in the process of the transaction. Mr. Hall failed, for whatever reason, to put the contingency in the contract with the seller. So the seller, in this case, Mr. Dedrick, was unaware that there was a contingency to sell the buyer's home before he could close. It was a problem because the seller in this case was actually moving out of state and had changed jobs, and obviously the delay posed a pretty large problem for him. Mr. Hall fully admits and has taken responsibility for the fact that he did not put the contingency in the contract. Mr. Hall states and will state that this was an error. He will, I expect, testify that he simply panicked when he realized that there was a contingency, or when he realized that he had not put it in the contract, and he just panicked, I believe is what he will say, and was hoping that they could just get the closing done and nobody would be the wiser, I suppose. Mr. McCormick does have some checklists in his office. I will introduce those into evidence. Does supervise a few agents. He'll tell you that his business is very small. And the testimony is going to be that Mr. McCormick simply had no idea that there was an omission in the contract. And I'm going to suggest to you that it's difficult to hold, it would be difficult, I believe, to hold Mr. McCormick responsible for an omission. It would be one thing if there were, something in the contract that shouldn't have been there, but he simply had no way of knowing that this contingency was left out. Will be our. Oh, I'm sorry. Yes, is this on?
But you're soft.
I'm soft. I am. So that will be our position. We have Mr. Hall to testify today, and Mr. McCormick will testify on his own behalf. And I appreciate your time. Thank you.
Thank you, Ms. Palmer. Ms. Ryan, you want to call your first witness?
Call Caitlin Maxwell. Mike, if you would.
Yes.
Would you please state your full name for the record
Caitlin Maxwell.
and your position with the state of Tennessee?
I'm the Executive Director of the Real Estate Commission
And how long have you held that position?
since September 2017.
Were you working for the state prior to that?
Yes.
What was your position prior to that?
I was the Director of Operations for the Regulatory Boards Division.
So you've been involved with the regulatory boards and the issues of regulatory boards since you've been working for the state?
Correct.
Now, is the Real Estate Commission or your division considered the keeper of the files and records of complaints and licenses?
Yes.
And that means that there would be a complaint file, if there was one, and definitely license files for everybody that is doing business of real estate?
Correct.
And does Mr. McCormick have a license?
Yes, he does.
When was he first licensed?
1997.
And what kind of license does he hold?
He holds a broker license.
And is he considered a principal broker?
Yes.
Where is his business, his principal broker? For what business?
He has a real estate firm.
Okay. Do you know the name of the real estate firm offhand?
Van McCormick Realty and Auction.
And do you know how many affiliates he has working with him?
I believe in the response 9 were included. There might be a few more now.
And what was the reason there was a complaint opened against Mr. McCormick?
Failure to supervise.
And based on what?
Based on his affiliate, there was a complaint filed against his affiliate that related to a contract.
And what were the allegations against the affiliate, or what did the complainant say happened?
The complainant said that they failed to include a contingency in their contract.
And the complaint was opened then against Mr. who?
Against Mr. Hall, and then a second complaint was opened against Mr. McCormick.
Failure to supervise.
For failure, yes, correct.
Okay. Is that the standard? Complaints opened against an affiliate and a principal broker at the same time?
Yes.
Okay. Did Mr. Hall admit to the allegations?
Yes,
Did he pay a civil penalty?
he did.
Okay. So you were saying that there was a contract issue. What was the contract issue?
The complaint stated that a contingency was left out of the contract.
And was the copy of the complaint sent to Mr. McCormick?
It was?
Did he respond?
Yes.
And what did he say in his response?
In his response, he said that he was not aware of the contingency being left off, that he was not aware of it until the complainant called him.
Did he say anything about what he does in his business and practices to overlook contracts?
Yes, he said that he has office policies and procedures in place.
Did he say that he looked at the contract before it went out to the buyers and sellers in this matter?
He did.
He did say he looked at it?
He said that he wouldn't have been aware that a contingency was left off because it wasn't included.
But did he say whether or not he looked at the contract?
If you want me to, I can
Please.
refer to them. So, as part of his response, I'll just read this. As required by VM Realty and Auctions, Mr. Hall provided copies of the Purchase and Sale Agreement, Amendment 1 and Amendment 2 to VM Realty and Auctions. These documents were reviewed and maintained in the office. No information included on any of these documents indicated that Mr. Walker had made his purchase of complainant's home contingent on the sale of his own home. During the course of the sale of the property from complainant to Mr. Walker, Mr. Hall did not ask any questions or seek any guidance from Mr. McCormick. Indeed, as Mr. Hall forgot to put the sale contingency in the agreement, there would have been no reason for him to ask questions about it, nor for Mr. McCormick to ask him. Mr. McCormick had no knowledge of the contingency. He first became aware of the issue when he received a telephone call from the complainant.
So it would seem that there was some meeting about this. Is that what he said in his answer?
Not exactly, just that he was not aware or that there should have been a contingency.
Now, did the principal broker say anything, or are principal brokers, as a general rule, do they keep copies of contracts that come into their office?
Yes.
And did he say that he kept copies of the contracts that came in the office?
It says reviewed and maintained in the office.
Okay. In a sales contract, does the firm get any money?
Yes.
So there was a financial interest for Mr. McCormick in this matter because the firm also gets paid?
Yes.
Okay. What does the law say is the responsibility of a principal broker with regard to an affiliate?
If you'll allow me to pull out my law book, I can read it for you.
Please tell us what you're reading.
Okay. I was going to read 6213, 312, 15. In the case of a licensee failing to exercise adequate supervision over the activities of any licensed affiliate brokers with the scope of this chapter.
Okay, and that's preceded by, that's what's give the commission power?
Violating any provision of this chapter, any rule duly promulgated and adopted under this chapter, or the terms of any unlawful order entered by the commission.
And what you're reading is under 312, which is what gives the commission the power to act, is that correct?
Yes, it's under discipline, refusal, revocation, or suspension of license.
So under 312, they have the power to act if there's finding a violation, as you said, for failure to supervise.
Correct.
Have you looked, or do you know what this commission has found as a failure to supervise in recent years?
I did a little research, and over the last 2 years, there's been roughly 40 disciplinary actions of failure to supervise. So
Filed or
40.
filed?
Oh, these were executed.
Executed.
Yes.
Okay. About 40. Okay.
And yes.
And what were the results? I mean, what were the reasons for the failure to supervise? Did you look at those as well?
So I wasn't able to look up each individual case, but I did do a little bit more research on around 14. And of those, there were various reasons. Some were other contract issues, some related to E&O, some related to advertising, some related to unlicensed.
Advertising is covered under the statute, is that correct? There's a
Yes,
separate
and under the
section.
rule.
But you said they also found a violation for contract issues. What kind of contract issues?
If you'll allow me to look at it, there was some various contract issues, some where it was not fully executed, some where reasonable skill and care was not provided.
This is on a contract?
So on one of the contracts, the issue related to a time was not specified as to when the contract would be terminated. There was no specific date on the contract. There's some that related to improper, fraudulent, or dishonest dealings.
But you just only mentioned one contract issue there in the ones you looked at?
No, there was roughly 4.
Roughly 4. And did in those particular cases was a civil penalty issued to the principal broker?
Yes.
And the principal broker signed a consent order and paid those?
Yes.
Okay. What are the civil penalties for violation of this particular law that is a failure to supervise?
They can be roughly anywhere from $250 to $1,000.
Ask you if I'm going to, Your Honor, can I
If she can step down, if
Okay, can she-
that'll help. Yeah.
if you would look at that, please. I had a copy of the complaint file in this matter. And that includes the document you were reading from earlier. That includes the response that was filed by Mr. McCormick?
Yes.
Okay, Your Honor, with your permission, I would like to pass
This
this
will be
out.
exhibit number 1?
Yes.
All right. Could you help us here? Would you get copies of those? And we'll mark these as exhibit number 1 and pass copies to the commission, please. Maxwell, is this one or
Yes, it's one. It's all one exhibit. It's
all one?
Yeah.
Okay. Should we take a moment to let the commissioners review this?
Sure. Let me just correct one thing before
All
we
right,
go further.
okay.
Now, in this letter that was sent to Mr. McCormick, it says it was sent November 6th in 2017. Is that right?
No.
Tell us about that.
Our system with letters, it includes the date that the document was printed rather than the date that it was actually sent.
Okay. So how can you tell what date it was actually sent? Did you look that up?
I did look it up, and I can tell that it was attached in our system sometime around June 2016.
2016. Okay. Thank you.
All right. Members of the commission will give you all a few minutes to review these documents. Commission, do you need more time, or are you ready to proceed? Another minute, that's fine.
Not yet. No.
Chairman, are we ready? Okay.
Thank you.
All right, Ms. Ryan, go ahead.
Your Honor, may we approach? And
Yes, yes.
Would you give this to her? Now, you were testifying earlier about the affiliate. Is this the affiliate in question, Mr. Hall?
Yes.
Is this a copy of the consent order?
Yes.
And what did Mr. Hall admit to in the consent order? What facts?
Would you like me to read the
Please.
facts? Okay, so under the stipulated finding of facts, respondent was at all times pertinent hereto licensed with the Tennessee Real Estate Commission, having been issued license number 295354. On or about June 3rd, 2016, complainant entered into a purchase and sale agreement with respondent located at 5607 Scenic Drive, Old Hickory, Tennessee 37138. In quotations, the subject property. The aforementioned agreement did not include terms that included the sale of the complainant's home was contingent upon the sale of the respondent's client's home. Respondent did not advise all parties involved that respondent had failed to include the contingency of sale in the purchase and sale agreement.
Thank you. Your Honor, may I pass that out to the... Thank you.
Number 2. All right, Ms. Ryan, go ahead, please.
Now, going back a little bit so we all understand, what is the complaint process? That is, when a complaint's filed, what happens next?
So, since I've started, the complaint process has been that the complaint comes in to our centralized complaints unit. They process the complaint. They send it out to the respondent for response. That then comes back. Then the complainant has the opportunity to respond to what the respondent responded. And then from there, it goes up to our legal division.
And what happens after it goes up to the legal division? Does an
Once
attorney review it?
An attorney reviews it, and then it's presented at our commission meetings.
Presented with names?
No, it's presented anonymously.
And then the commission can make a determination?
Yes.
And so then a respondent has an opportunity to resolve whatever issues, if there's a finding, prior to having a full hearing?
Correct.
So was Mr. McCormick given a proposed consent order?
Yes.
And there was no agreement on it?
Yes.
Now, do you know if all the information, that is not just what the complaint says, but what the respondent says, is that all that information is what's presented to the commission to review in the first place?
Yes, they're presented with a summary of both what the complainant said and what the respondent included.
So we're here today not because of the underlying matter, but because there was an agreement about a failure to supervise.
Yes.
And that's the issue we're here on today.
Yes.
Thank you. I have nothing further.
Palmer.
Good morning, Ms. Maxwell. Remind me if I don't speak up enough for anyone to hear me. Can you tell me, Ms. Ryan asked you about prior failure to supervise complaints, and I believe, correct me if I'm wrong, you indicated that there have been 4 prior complaints related to contract issues.
In the last 2 years.
In the last 2 years, 4.
4 that have been executed, meaning that the principal broker paid and met the terms of the consent order.
Do you know whether any of those 4 involved an agent who failed to put something into a contract such that the principal broker wouldn't know that it was omitted?
One I know I mentioned earlier was there was no termination date. I don't have the particular consent orders for each of these in front of me, and so I know there were 4 contract issues. I don't know the details of each.
Can we agree that failure to put an expiration date in a contract is something that would be easily identifiable when you review the contract, because it's supposed to be there, but it's not?
Not being a subject matter expert in real estate, I don't review the contracts all the time, so I'm not sure I feel comfortable answering that.
Okay. Can we agree that if a principal broker reviews a document and there's a blank in the document and an indication that a date should be there and there's no date, that's fairly easy to recognize?
I'm going to object, because unless she is testifying in the role of principal broker or a licensee, she's really not competent to answer that question.
And I would say, as the executive director of the Real Estate Commission, she should certainly be familiar with how contracts are executed.
Well, if Ms. Maxwell, if you are able to answer the question, then you do so, please. But if you feel like you don't have the knowledge or background to answer it, then that's fine.
I know termination date is referenced in the statute, in the rules. I don't review contracts frequently. I hear about them from the complaint process, but I'm not actually reviewing contracts.
Do you know whether the statute or the TREC rules define failure to supervise?
There are 2 instances where it specifically references failure to supervise, as it relates to E&O and as it relates to advertising. What I did mention earlier, and I read into the record, also mentions failure to supervise, and I can reread that if you would like.
Talking about 312B15?
Yes. 14 and 15.
If you would, go ahead and read 15 again.
In the case of a licensee failing to exercise adequate supervision or the activities of any licensed affiliate brokers within the scope of this chapter.
And other than referencing the words failure to supervise, does it define what a failure to supervise means or give examples?
Not give examples.
Is there a definition anywhere in the statute of failure to supervise that you know of?
Not that I know of.
Is there any in the TREC rules?
There are references when it relates to, I know for sure that there's references when it relates to E&O and advertising.
Do you, as the executive director of TREC, know whether a principal broker is required to sit down with each agent on each transaction and go over each provision of the contract line by line? Okay. Do you know whether a principal broker is required to question the agent about matters not in the contract?
No.
Do you know whether a principal broker is required to suggest additional terms that should be in a contract?
I don't know.
Do you know whether a principal broker is required to speak with the other party? In this case, it would have been the seller, to personally speak with the seller about the transaction.
I don't know.
Do you know whether the principal broker is required to ask his agent about adding provisions to the contract that are not there when the principal broker reviews it?
I don't know.
Do you know the average number of agents in a typical real estate office in Tennessee?
No.
And do you have an opinion as the executive director as to whether it's even feasible for a principal broker to sit down with every agent on every transaction and go through the contract line by line?
I don't have an opinion.
What the recommendation of the, you talked about on direct examination about the process that was gone through in this particular case to reach the consent order. Do you know what the attorney's recommendation was as to Mr. McCormick at the time of the initial hearing?
I do not know offhand, but I could get that information for you in our system if you want.
If it pleases the commission, I would like you to do that.
Okay.
Your Honor, I'm going to object because what the attorney recommended is not relevant at this point in time because the decision is made by the commission and the commission alone based on the evidence and the matters presented to it, and it's the commission's decision, not the attorney's decision.
I agree with you, Ms. Ryan. Let's move on, Ms. Palmer.
I think that's all I have. Thank you, ma'am.
All right, anything else from Ms.
Yeah.
Maxwell, Ms. Ryan?
Yes, just a minute or two more. Now, you testified what you didn't know, right? You are a licensed, you do have a license as a real estate person.
I do not.
Okay.
I have passed the broker's exam,
Yes.
but I am not a licensed
But
real
you've not
estate
practiced
agent.
in it.
I
That's
have
right.
not practiced.
The members of the commissions, are they all licensees?
No.
How many are not?
2 are not.
So the persons that are on the commission are in this practice on a daily basis?
Yes.
And do you know how many of them? And don't say who. It might be principal brokers?
I think I know.
How many?
I think roughly, I know 7 are industry members, so I think at least 5.
Are principal brokers?
Yes.
Okay. So when you present that what you don't know and you don't understand, That's not the issue. These are issues that are generally determined by the commission based on the laws at place.
Correct.
Okay, I have nothing further.
All right. Members of the commission, any questions for Ms. Maxwell?
Anybody have a question for Ms. Maxwell? Ms. Maxwell, Mr. Hall, he signed a consent order that provided for a $1,000 civil penalty and 4 hours of continuing education.
Correct.
I see a copy of a check for the $1,000, so I assume he paid the $1,000 civil penalty.
Correct.
Do you know if he attended the 4 hours of continuing
It is
education?
my understanding that he's met all terms of his discipline.
Thank you.
Thank you, Ms. Maxwell.
And that concludes the state's proof, Your Honor.
All right. Ms. Palmer?
I'd like to call Mr. Hall. Who's in the-
All right. Could you get Ms. Hall, Mr. Hall, please? Or Mr. Hall, would you sit up there, please, sir? Speak into the microphone so we can hear you, sir.
I do.
Thank you. Go ahead.
Mr. Hall, good morning. I guess it's still morning.
Yeah.
You are a licensed real estate agent in Tennessee.
Yes, ma'am.
How long have you been so licensed?
Since December of '04.
How long have you been working with Van McCormick Realty and Auctions?
Since about 6 years.
You had occasion, did you not, to be retained by Mr. Walker?
Yes, ma'am.
And was Mr. Walker a buyer or a seller?
He was a buyer
All right.
and seller.
Buyer and a seller. Explain that.
Well, he was looking to buy a house, and he had a house to sell.
And did Mr. Walker tell you at the time that he engaged you that selling his other home would be, purchasing a home would be contingent on selling his other home?
Yes, ma'am.
Okay. So you knew that from the beginning?
Yes, ma'am.
All right. And did Mr. Walker find a property to purchase?
Yes, ma'am.
Who was the owner of that property?
Mr. Dedrick.
And that's the complainant in this case?
Yes, ma'am.
You could just please explain what happened that causes you to be here. Just start from the beginning.
Found a place, Mr. Dedrick's, and a hurry. I got in a hurry. My fault. That to put an offer in on the house, and I wrote up the contract, put an offer in on the house, and so in doing so, I did not put contingency on it.
Why were you in a hurry?
Time limit. They were wanting offers just as quick as we could get them to them.
And did you notes when you were speaking with your buyer about what he needed or wanted in the contract? Like that he wanted a contingency?
Yes, he did want a
clause?
contingency. Yes, he did.
Did you make any notes about that when you spoke with him so that when you got an offer you would be ready to insert it?
I wrote it down on a note. Yes, ma'am.
Do you have that note?
No, ma'am.
What happened after the contract was signed? Well, first let me ask you, Mr. Walker, your buyer, reviewed the contract before he signed it? All right. Were you present when he did that?
Yes, ma'am.
He didn't notice that you failed to leave out the
No,
contingency?
we just did it in a hurry, and he signed it.
And then what happened when it came time to close?
The house that is his house that was selling, everything wasn't going through, closing wasn't going through. And that's when, like I say, it was all my fault. Mr. McCormick didn't even know anything about it. I did not tell him. When I found out, when I wrote it up, a couple days after that, I realized what I did. I was scared, embarrassed, frightened, and I made a decision. It was a wrong decision, but I did not tell Mr. McCormick anything about it.
Do you recall what the date of closing was in the contract?
31st of May.
And did you close on the 31st of May?
No, ma'am.
What happened to delay closing? How did that transpire?
All their paperwork wasn't in, and first time it was to June the 3rd, then I think it was June the 10th, and then the last was June the 16th.
When did you realize that you had left the contingency out of the contract?
A day or two after I signed it.
So at the time you prepared the contract, you didn't realize it?
I didn't realize, no.
How did you come to realize it?
I realized I got to sell his house.
Okay. And when you realized it, what did you do?
I made a poor decision that I would take and sell his house without notifying my broker what had happened, what I did.
Did you, on behalf of your buyer, request that the seller extend the closing date?
Ma'am?
Did you, on behalf of your buyer, request that the seller extend the
Yes, ma'am.
closing date
Yes,
on
ma'am.
this property? Okay, and what did he say?
He said, okay.
And it was extended to when?
The first time was the 3rd.
Of June?
Yes, ma'am. Second time was the 10th.
Your Honor, I think we all know the issues here, and I think that this information is not necessarily relevant. The question is whether or not, in the end, there was a failure to supervise, and he has already resolved his particular issues with this commission by signing an agreed order. And the issues really are the supervision and not necessarily the details of what happened at this point. So I think that we're going well beyond what is necessary.
I'll move on.
Okay, that's fine.
Mr. Hall, my point was there were several opportunities along the way for you to reveal to the seller that the reason that closing was being delayed is because there was a buyer on the other side, or a seller on the other side, who was having problems with his house that he had to sell before he could buy Mr. Dedrick's house.
So I told him they knew about it the first time.
You had several opportunities to tell them.
I did tell him the first time.
You told him the very first time.
Yeah, the very first time.
Okay, and what was his reaction?
They didn't like
Objection,
it.
again, it's not relevant. The issue is whether or not this failure to supervise. The issues concerning Mr. Hall and the particular person are resolved in the consent order. So the issues here today are whether or not there was supervision by this particular principal broker, not necessarily relations with the buyer and seller in that sign, because that's been resolved.
I'll give Ms. Palmer a little latitude here. I mean, I think that she can have Mr. Hall testify about what went down and any communications that he may or may not have had with Mr. McCormick about it. So go ahead, Ms. Palmer.
When you first realized, you testified already, when you first realized you didn't put the contingency in, you did not speak with Mr. McCormick about that.
Know nothing about it.
And when you told Mr. Dedrick that there was a contingency, which he had not known before, and he was understandably upset. You did not tell...
Objection. She's testifying to some reactions about something who's not here.
Not lead, Ms.
Well, I think
Leading.
I think I already asked you, and you've already testified that you told Mr. Dedrick and he was upset. All right. At that point, did you go to Mr. McCormick and let him know about what had transpired? When you put the listing and well, let me ask you this. When you have a listing and you get a contract, do you provide that contract to Mr. McCormick?
Yes,
Is that contract maintained in the office?
yes, ma'am.
Does Mr. McCormick review that contract to your knowledge?
As far as I know, yes, ma'am.
All right. You put the notes that you took regarding your buyer's
Ma'am.
request for a contingency in that transaction folder
No.
such that Mr. McCormick would have seen them?
Your Honor, could we just ask Mr. Hall to speak up just
So
a
you're
little
going to
bit?
have to speak up, Mr.
All
Hall.
right.
Thank you.
I'm sorry.
That's okay.
I believe your answer was no, correct?
No.
All right, thank you.
At what point, if you know, did Mr. McCormick learn of the problem?
When Mr. Dedrick called him,
What happened when Mr. McCormick learned of the problem?
he called me, wanted to get it straightened out, and we tried to sit down and talk to Mr. Dedrick about it.
And what happened?
Well, Mr. Dedrick didn't like what we offered.
Did you take responsibility to Mr. McCormick for this mistake?
Yes, I did.
Did Mr. McCormick counsel you in any way?
Yes, he did.
Tell me about that.
He, he didn't cuss, but he got on to me quite a bit, which I deserved it.
And you have you received training in the duty of due care to your clients?
Yes, I did.
Have you received such training from Mr. McCormick?
Yes.
And you were well aware of that duty?
Yes, ma'am.
Right. I think I have nothing further right now.
Right.
When you were preparing the contract, what checklist did you use to make sure the contract was adequately filled out? No checklist? So you have no office checklist that says, are there contingencies? Are there issues? Are there repairs? You don't have a checklist to go over when you're making a contract?
We have a list on things, itemized list of things, but I don't believe that's on there.
So issues of contingencies are not on an itemized list that you should be looking at on a contract?
I don't understand, ma'am.
Well, if you're preparing a contract, is there not a list that says, are there contingencies that you need to fill out and be aware of? Is there a list for that? That you check on before you fill out a contract? So there's no office standard list that shows what a person should do when they're negotiating a contract with a buyer or seller. There's nothing there to guide you to what should be in the contract or what shouldn't be in the contract.
We've got a folder that says a list. He's got a list of things that should be in there.
Contingencies are not on that list?
I'm not sure.
Do you meet with Mr. McCormick every time you have a contract, or does you just give him a contract to review?
Give him a contact to review.
So there's no meeting or talking about what's in the contract and the results of the contract or problems that may come up in any particular sale?
I'm having a problem with it. No, ma'am.
Well, how often do you meet with Mr. McCormick on a one-to-one basis about your responsibilities as an affiliate in the office?
A week.
And you don't go over things like what you should put or shouldn't put in a contract?
He's got a list of things that we should have.
But it doesn't have contingencies on it. You can't look at him, sir.
Well, I don't know. I'm
Okay.
be honest. I don't know.
Okay.
I don't know.
Okay. And you did not go over this contract with Mr. McCormick before it was sent out?
No, ma'am.
I have nothing further.
Else, Ms. Palmer.
Nothing at this point.
All right, members of the commission, questions for Mr. Hall?
Mr. Horn, you want to go ahead?
Yes, sir. I'm just a little bit confused why you said you were frightened and you would not talk with the broker. Was there something else that I'm missing the point here?
No, I realized what I did. I made a mistake. I was scared. What I did. I was embarrassed, ashamed. I'm 73 years old. I don't need this.
Almost 80. I make mistakes. But I would definitely talk to Caitlin if I thought I had made. I just seemed like that's where you would stop. with your
You're right.
broker.
You're right, sir. I should have.
Okay, I'm
You're right.
Right, Mr. Bloom.
Yes, sir. Mr. Hall, I see in the notes that your office is adjacent to Mr. McCormick's office. Is that another office building?
No, it's the same building.
Okay. Okay. So you operate out of the real estate office building? Okay.
Right.
All right.
Ms. Hills.
And did this property close?
No. Oh, which one that?
On Scenic Ridge Drive? Did
Yes,
it did close?
Yes, he had a backup contract on it.
So you did not
No, I did
ever
not.
close?
No, ma'am.
So Mr. James Walker never purchased the property?
No, ma'am.
Okay. And so you had the listing for Mr. James Walker. You had his property listed for sale when you wrote the offer.
No, ma'am.
You did not have his personal
No,
property
no.
for sale?
No, ma'am.
Okay.
So that's when I realized I made a mistake.
Okay, so it was not for sale at the time?
No, ma'am.
Okay. And it had that it was a conventional loan. Did you have a lender's letter saying that it would need to be, that he would need to sell his house for the loan?
No, ma'am.
Okay. All right.
Mr. Douglas?
Yes, I have
Go
several
ahead.
questions. I know we're not here to hear allegations regarding Mr. Hall's failure to exercise reasonable skill and care with his client, but Mr. McCormick's failure to supervise, correct? And but I do think these details are relevant. You know, there are certain things that you supervise and certain, required by law, and certain things you don't. I did have a question, though. Was Mr. Dedrick represented by an agent?
Yes.
I mean, I see that in the confirmation of agency status here, and I was wondering, did he review the contract for Mr. Dedrick, and did he not maybe ask any questions with regard to contingencies? And then I also wondered, did Mr. Dedrick, I think I got the name correct here, whenever he put an offer on his property in New Jersey, did he not write a contingency for the sale or successful closing of the home in question here on that one?
Should have. He was an agent.
Hey. Was there a financial contingency? Well, it appears there's a financial contingency in the contract, correct?
Yes, sir.
Okay. I think that's all the questions that I had at this point. I mainly just wanted to know, was he represented by an agent himself?
Yes, sir.
Okay.
Ms. Frakes.
Mr. Hall, we have a copy of your independent contractor agreement, and it says on line 37, licensee agrees to follow agency's policy manual, which is incorporated herein by reference. But we don't have a copy of that manual. Did you have a copy of that manual? The policies and procedures for the office?
Yes, I do.
Okay. And do you have any idea how many pages are in that policy and procedures manual?
No, ma'am.
And is that something that your broker updates from time to time?
Yes, he does.
And does he have you sign that you agree to to do all those things that are in the policies and procedures?
Yes, ma'am.
And does it have anywhere in those policies and procedures what to do when writing a contract, and specifically if there's contingencies involved?
Don't know.
Is your office required to use the TAR contracts?
Yes, ma'am.
Okay, so the TAR contract that you were using, I noticed, was from 2010, and you wrote the contract in 2016.
Yes, ma'am.
Is there some reason that the office was using 6-year-old contracts?
No.
Is this? I'm just wondering if you, so. Do you have copies of contracts that you make ahead and you file it? So if you need a purchase and sale, you can run in there and grab one of those purchase and sales.
I have done that. Yes, ma'am.
Okay. Do you think that's what maybe you had done on this with it having a 6-year-old contract in it?
It would have to be, I guess.
Okay. Okay. Hang on a second. Let's see here. I did see that you had 2 contingencies marked. You had one marked for the appraisal, and you had one marked for the financing. Where would you typically put a contingency for the sale of a home in your contract?
Stipulations.
Okay, and how many at the point of this in 2016? Approximately how many houses have you sold at that point?
Probably 25.
Okay, and so that a year you're averaging 6 or 7 a year, maybe.
Yes, ma'am.
Okay. And had you ever had an occasion that you had a contingent, a contract that you wrote that was contingent on selling someone else's home?
No, ma'am.
So you never had to write one like that?
No, ma'am.
Okay. Now, under your stipulations, you did put in here, seller to pay up to $5,800 of purchase price towards buyer's closing costs and prepaids. There's going to be a fence installed and a bathroom that was to be finished. And then you have 2 amendments. Would you agree that, again, would have been a place that you could have put that stipulation, the contingency?
Yes, ma'am.
Okay, so the Amendment 1, and let's see, it was written April 15th. And you had a binding agreement date of 4/15, but this amendment was signed on June 16th. Okay, so why later, 2 months later, did you have this amendment to the purchase and sale agreement that says buyer agrees to pay an additional $500 plus forfeit the earnest money of $500 already paid to Parrish and Associates in the event this transaction fails to successfully close on or before June 10th? It's your Amendment 1, and you came back after it was a binding agreement, and you amended that agreement to say if it doesn't close by June 10th, 2016, that the buyer agrees to pay an additional $500 plus forfeit the earnest money of $500.
Right.
Okay, so what happened that you thought, or they thought, there might be an extension on that contract, on that closing?
Well, they knew it on there that it was be extended.
So by this point, did everybody know about the mistake that you had made?
Yes, ma'am.
So is that why you put it in here?
Yes, ma'am.
Okay. So you didn't get all the way to the closing date, and then your broker found out about this. Is that correct?
I don't understand what you're saying.
Well, you have an Amendment 1 that was written on June 1.
Right.
And when was it supposed to close? When was that contract supposed to close?
The 31st
of
May.
Of May. So when it didn't close, that's when your broker found out about it, right? when it wasn't going to close, Mr. Dedrick called your broker and said, we're not closing because he didn't put it in?
No, I don't think so.
When did he notice? When did he notice that contingency wasn't in there? Is it when the deal fell apart in New Jersey because they couldn't close?
When he received a call from Mr. Dedrick.
Okay. All right, and then there's an amendment that's an unsigned. Amendment 2 is unsigned. It says in consideration for an extension. So you're going to give them $2,500 more to extend to June 16th. Correct?
We were, yes.
And why did they not sign it? Why did nobody sign it? Buyer or seller?
Just flew apart.
Okay. All right. So your broker knew nothing about this until that man called and wanted to have a meeting with y'all.
Yes, ma'am.
I thought I saw in here somewhere that there was an office checklist.
It was.
And is that on your folder, or is it a sheet of paper that's loose?
It's loose in this. It goes in our folder.
Okay. All I have.
Ms. Taylor.
A couple of questions, if you don't mind. On the amendment number 1,
Yes,
which
ma'am.
was written and signed on June the 1st,
Yes, ma'am.
your contract was supposed to close on May 31st, correct?
Yes, ma'am.
I see no extension of a closing date. Was there one?
It should be one. Yes, ma'am.
It's not here.
Okay, it should be one.
So actually, you didn't have a contract if you did not extend it. Is that correct?
Yes, ma'am. But I'm pretty sure I had the extension on it.
Well, if in the event I see that it says this agreement is to be paid outside on the June 1st. It says this agreement is to be paid outside of closing by the buyer in the event the buyer is unable to close on or before June 10th. But that was written on the 1st and signed on the 1st. Well, it was signed on the 16th. Signed on the 16th. June 16th. Oh, June 1st. Excuse me, I'm looking at the wrong thing. So the contract is already over. When did Mr. Dedrick call your broker? Do you know that date?
Somewhere in June, and sometime in June.
Oh, it was after the contract was already null and void, basically. Is that correct?
That's what it is, yes, ma'am.
All right. Now, is there a policy in your office if a contract is supposed to close on the 31st because and it doesn't close on the 31st? What is the policy in your office?
To notify our broker.
Well, your broker would not be aware that anything that's booked to close does not close. Is that correct?
Yes,
So he's not made aware that something that's supposed to close does not close. There's no. Does your broker have a?
Yes,
checklist
ma'am.
with it?
We give him a list of what that is supposed to close on certain day. We tell him.
Tell him, but if it doesn't happen, what happens then? Nothing, or do you know of any policy?
Well, he comes to us and asks what's going on.
And did that happen?
On that?
He did not ask you. Is that correct?
Yes, ma'am.
And I want to be sure you said that Mr. Dedrick, and he was the seller of the home in question.
Yes.
Did not call your broker till in June?
Yes, ma'am.
Which is after the house was supposed to close?
That's my recollection. That's what.
What do you do to prepare for your closing, you give you have a closing attorney, I'm assured, and you ask for earnest money if you have it to go to the closing attorney, and your buyers and sellers supposed to be informed their closing attorneys. So did anything like that happen before May 31st?
Yes, they informed us that our tile escrow it was handling it.
But you didn't make arrangements, or did you and your buyer make arrangements to go to closing on May 31st?
No, because we was having problems with the financing on the house.
And you would know, how long do you think we would be before closing, before the bank informed you that the closing couldn't happen on the May 31st? All right, your buyer had to get a loan.
Yes, ma'am.
So he has to get a loan through a bank. And
Yes.
the bank is going to say, okay, you're qualified by a certain date
Yes, ma'am.
to go ahead to closing, or they're going to say you're not qualified by a certain date, so you can't go to closing. Is that correct or not?
That's correct.
All right. So did the bank inform you that you could not close by May 31st?
They asked me what was going on. Yes, ma'am.
And when did that happen?
Sometime a few days before May, before closing.
And so who was informed at that time?
It was me.
And then what did you do with that information?
I told them we were working on it. That we
Told who? Who's him?
Frankie at Tile Escrow.
Did you tell your broker?
No, ma'am.
That?
No, ma'am.
And you told not only the person at Title Escrow, but who did you tell anyone else?
No, ma'am.
And so if you knew you couldn't close on time, there's no policy in your office to inform anybody else except yourself and the buyer that you're not going to be able to close on time?
Supposed to inform our broker.
I have no further questions at this time.
Ms. Franks.
So, do you have in your office, do y'all have like a board up that shows what your closings are, when they're going to be? Do you have any kind of board like that in y'all's office that you do that in, or do you just have the files?
Have the files.
You just have the files. So, so when you give the information at your office on a contract, you get a contract, and who do you give that copy to in your office?
Broker.
All right, so you don't give it to the secretary or any kind of person doing that. All right, so you give it to the broker then. And so it was supposed to close on May 31st, but 16 days after the closing is when Mr. Dedrick called your broker, correct? So there was a delay of 16 days there. Did your broker ask you what's going on with that contract? Was it not closing?
It asked, and I told him that we're having to extend it.
And why were you having to extend it? What'd you tell him?
Because they're having problems with the closing on the house of Mr. Walker's.
And what was the problem?
They couldn't finance. They were foreigners.
Wait a minute. All right. So the problem, who couldn't finance?
People that was buying Mr. Walker's house.
Okay. So you told them they couldn't close because they were foreigners?
No. They were having problems getting information about their job related and all that.
So these people, did they have a home to sell and you also had that listed? Your buyers, were you trying to sell the home they had?
Yes, ma'am.
Okay, so were you not having luck selling that house? That's what held you up from them closing, right? Okay, so had they have closed, then you'd been okay without having that contingency in there. That's what was in your mind. You're thinking, I got to get this house sold, and then it'll all work its way out, and that's why I don't have to tell my broker, because you were embarrassed about it, and so you thought it would all work out. Well, were you showing that house a lot, the one that you had to sell first?
Yes.
So it was being showed a lot. So you thought you were going to be able to sell it before this closing date. Okay, so I'm a little confused. I'll tell you, I'm a principal broker.
Yes, ma'am.
And there's nothing more sacred in my office than closing day. And I'm looking forward to closing day because that's payday for everybody. So we all look forward to the payday. I'm just wondering how 16 days could have passed and you be able to satisfy your broker that everything's in the works. I would have been digging down and saying, why. I would have really been digging down on you. 16 days is a long time. So I'm wondering, what was he saying to you during those 16 days when you were just telling him, I've got this, you called them foreigners, and they were having problems.
Yes, ma'am.
What, was he trying to help you to get whatever their remedy was? Did he never know that the part of the remedy was they had to sell their house?
No, ma'am, he didn't.
But he had the listing, and you had the listing on that house, right?
Yes, ma'am.
So nothing ever are they going to get a bridge loan? They're going to have two houses? Because you got the listing, and they're buying a house over here. So I would be getting very nervous and asking you, how's it coming on that house? You're going to get that house sold. Wouldn't he have known to ask you? Why did you not put a contingency in here for the sale of that house? Or are they going to get a bridge loan?
Don't know, ma'am.
Okay, that's all I have.
Right, I have just a couple of questions.
Yes, sir.
Good morning, Mr. Hall. Thank you for
morning.
being here. So just so we're clear, Mr. Walker came to you and said, I want you to help me sell my house, and I want you to help me find another house. Is that right?
Correct.
So I see that your contract here for the one that Mr. Walker was going to buy from Mr. Dedrick was dated April 15th, 2016, right?
Right.
So he came to you before that with wanting your help. Is that right?
A few days before that, yes.
Okay. And so did you immediately start trying to sell Mr. Walker's house?
No, we just he said he wanted to see what was out there. And
Talking about what you were trying to do to help Mr. Walker sell his house.
no,
Did you go ahead and list it?
no, not right then. I told him that he just wanted to see what was on the market, see what the prices were going. And one came up in the area that he wanted to be in. That's why we jumped on that one.
And that was Mr. Dedrick's house.
Yes, sir.
So when did you start trying to sell Mr. Walker's house?
A few days after contract on the house, Dedrick, that I realized what I've done.
So you said Mr. Walker came to see you a few days before April the 15th.
Yes,
Is
sir.
that the first time?
Yes,
Right.
sir.
How did you know Mr. Walker?
I see him all the time. He worked in a pawn shop in Madison.
So you've known him for a good while.
Yes.
So at what point did you tell Mr. McCormick what you were trying to do to help Mr. Walker? That he was a client and you were helping him buy and sell? At some point, after Mr. Walker came to see you and said, Mr. Hall, I want you to help me sell my house and I want you to help me find another house, at some point did you go to Mr. McCormick and say, I'm helping this fella, Mr. Walker, with some real estate transactions? Did you ever go and tell Mr. McCormick that?
I told him I had a client. I never did tell.
Okay.
That I was looking.
Did Mr. McCormick understand that you were helping Mr. Walker with both a
No, he did
purchase
not.
and a sell?
No.
Okay. So at what point did he understand that you were helping Mr. Walker with both transactions?
I'd say the last of on the contract and everything.
Like,
Well, I mean, I might have told him that I was working with Mr. Walker on both of them
when was that?
sometime during the contract.
Okay, but you're not sure when.
No, sir.
So whenever you gave this contract to Mr. McCormick to look at around middle of April, did Mr. McCormick know that you were going to be trying to help Mr. Walker sell his house?
No, not at the time.
Okay, so when did you actually start listing Mr. Walker's house for sale?
Probably 4 days, 4 or 5 days after that.
Okay, thank you. Go ahead, Ms. Franks.
So, you had to have paperwork. You found the house before you listed Mr. Walker's house, right?
Right.
All right. So you had to take that purchase agreement in on that. So within 4 days, you listed Mr. Walker's house. And then when you listed it, where does your listing agreement go? What did you do with it?
The listing agreement goes in the files in our office.
And so, do you give that to Mr. McCormick?
Yes, ma'am.
Or do you give it to some staff person in your office?
No, I give it to Mr. McCormick.
So, Mr. McCormick, 4 days after he got the contract that you gave him, that you'd written on Mr. Dedrick's house, 4 days later, you gave him the listing agreement. So he knew on 4 days later that he had you were listing this person's house to sell, and that you had found them a house.
Yes.
4 days. And that was during what month? Maybe April?
April, yes.
Okay. So from that day in April, he should have known you were selling that person's house and you had contracted for them to buy a house, correct?
Correct.
Okay, that's all.
Any other questions? I think we've
Seeing
asked
none?
all
All
we
right,
can. Thank you.
Thank you very much.
There were some of the issues that I would have raised were objected to, and the panel has hit on some of them. And I think I can clarify.
All right, go ahead, Ms. Palmer. Briefly, please.
Mr. Hall, the contract that you used, you said it was a Tennessee Association of Realtors contract. You don't have a copy of that in front of you, do you?
Speak into the mic, sir.
No, ma'am.
I would have introduced these with Mr. McCormick, but if I may, I would like to just introduce my packet as well.
All right, what is that, please?
It includes the contract, the amendments.
Well, Your Honor, the
I believe we
contract
have that,
amendments
Ms.
are in
Palmer.
the.
All right, then I'll leave out the consent order, and I'll leave out the,
They're all included in the documents that I.
do you have the emails regarding the
No, but
extension?
just the contract itself.
All right, well, I'd like to submit the 2 checklists that I have.
That's why she's up, because the contracts are on there.
Do you want me to just remove the checklists? And
Well, I just want to know what you're asking him to look at, so I can see it. Are these just the 2 documents you're looking at?
yeah, I'm going to look at the.
I'll tell you what, members of the commission, why don't we take a very short break here
That's
and
good.
while they get these documents together. All right.
5 minutes.
Yeah.
Thank you.
Those should. Yeah, that's a problem. Okay. May I approach?
Yes. All right, are we putting this in as the next numbered exhibit, Ms. Palmer?
Yes.
All right, could you have your witness identify what these are, please? They'll be marked as exhibit number 3 without objection. Go ahead.
Tell me if you recognize those documents.
Yes.
All right. What do we have on the top of that pile?
Transaction file checklist?
Right. Is that the transaction file checklist that is used in your office?
Yes.
Is that the one that was used at the time of the events in question?
I think so.
And is there a second checklist there as well?
Yes.
Is that the purchase and sale agreement checklist?
What are you saying again?
Purchase and sale agreement timeline checklist. Do you have that as well?
Oh, you're talking about this? Yes, ma'am. I was looking over there. I'm sorry. Yes.
Now, Mr. Hall, your purchase and sale agreement is in that packet. It's been actually submitted twice. Do you see the purchase and sale agreement? Do you have the purchase and sale agreement in front of you?
Yes, purchase.
The purchase and sale agreement, the contract.
Yes, yes,
All right. And that is a TAR form, correct?
yes.
What is the year on that form?
1/1/16.
Okay. And, okay. Now, just going back to the chronology of events with respect to the closing, you indicated that the closing in the contract was May 31st, correct?
Yes.
And there were, did you have communications with the people on the other side of Mr. Walker's transaction? And
I'm going to object to the leading on that.
the question was, did you have communication with the people on the other side of Mr. Walker's transaction?
All right, I'll go ahead.
Yes.
Who were you communicating with?
I was communicating with the other agent and with the bank.
And in that packet that I just gave you, Can you tell me if there's an email in there?
Yes.
Recognize it?
Yes.
What is it?
It's apology for the delay.
Who's the email from?
Laura Dahl.
And who's Laura Dahl?
She was an agent that was buying the house,
An agent that was buying which house?
Mr. Walker's house.
All right. And what were her clients' names? I'll refresh your recollection as to what the clients' names were.
Patel.
Mr. and Mrs. Patel.
Patel.
All right. What is the date? What is the substance of the email that Ms. Dahl sent you?
She apologized for the delay on the respond about Mattel's loan.
And what is the date of that?
I'm going to object to the relevance. Again, the issues are not really what happened in the ultimate transpired here, the absolute details. The issues are whether or not there was a failure to supervise by this principal broker. So unless he was involved in the emails or then unless there's somehow an involvement here, I'm object to it as the relevance.
Well, I think the panel was curious about, in particular, the amendments and the timing of everything. And there are amendments in the packet that I will get to that will show that the closing was in fact extended at least twice. And those documents were placed in the file.
I'm going to overrule the objection. The commission's spent an extensive amount of time asking Mr. Hall about all the ins and outs of this transaction. So the commission has made this all relevant. So go ahead, Ms. Palmer.
Mr. Hall, what is the date of the email that you received from Laura Dahl?
5/25/16.
Okay. And that was prior to the closing. Was that prior to the closing date in the contract?
Yes.
And as a result of that, did you execute or did you speak with the agent on the other side on the Patel contract?
Yes. Yes.
On the on the Dedrick contract.
That's correct.
And did you advise him of the problem?
Yes, I did.
Did you request that closing be extended?
Yes, I did.
And was it extended?
Yes.
Do you have a closing date / possession date amendment in your packet?
Yes.
Can you tell me whether that was executed by both sides?
Yes.
And what date was it executed on?
Uh, 6/1.
Okay, I want you to look at how many amendment dates do you have there? Or how many amendments do you have there?
1, 2. I have 3.
Can you please look at the one that says closing date / possession date at the top?
Yes.
On what date was that executed?
5/26.
All right. So that was 5 days before closing was scheduled, correct?
Right.
Was that amendment placed in the file at the office?
Yes.
Right. And what date was the closing extended to pursuant to that particular amendment?
June the 3rd.
Did closing occur on June 3rd?
No, it didn't.
Why not?
Till financing.
All right. And did you advise Mr. Dedrick's agent that closing would not occur on June 3rd?
Correct.
Was another amendment executed?
Yes.
And what date was that amendment executed? Do you have a second amendment in front of you?
Amendment 2, sales agreement.
Actually says amendment to purchase and sale agreement, amendment 1. Do you have that?
Amendment 1, yes.
All right. And was that amendment executed?
Yes.
What date was it executed?
6/1/16.
6-1. All right. And in the 6-1 amendment, what was the agreement regarding the extension of the closing?
To June the 10th.
And there were some terms that were negotiated with Mr. Dedrick regarding that extension. Is that right? What were those terms?
That he'd be paid additional $500, forfeited if it did not close.
And all through this time, Mr. Dedrick knew that there had been a contingency, and his agent knew.
Yes.
All right. Did you provide this amendment to Mr. McCormick and put it in the file?
I put it in the file. I didn't inform him.
Did you tell Mr. McCormick why these 2 amendments were executed?
No.
Specifically that you had
No.
failed to include a contingency?
No.
And then did closing occur on June 10th?
No.
Was a 3rd amendment executed regarding closing?
For the June the 16th, yes.
Well, okay, so 1 was presented.
Presented, right.
And were there terms of, was there an offer from Mr. Walker in terms of things that he would give in exchange for that?
Yes.
And did Mr. Dedrick accept those?
No.
All right. And so that amendment, that last one, was never signed, correct?
Right.
All right. And at that point, you still had not advised Mr. McCormick that there was a problem with the contingency. Is that right? And I think Commissioner Franks asked you, it was approximately June 16th that Van received a call?
Or Mr. Dedrick, right.
Checklist, the transaction, can you explain the difference between the transaction file checklist and the purchase and sale agreement timeline checklist?
Which one, ma'am?
Please explain the difference between the transaction file checklist and the purchase and sale agreement checklist. You should have them both in front of you. First, just tell us how is each one of these used? How and when?
When you write up the contract,
Which one is used when you write up the contract?
purchase and sales agreement.
Did you complete one of these for this particular transaction between Mr. Walker and Mr. Dedrick?
I believe I did.
Were you able to locate that in preparation for today? When is the transaction file checklist used?
Same thing when we write up the contract or we sell one.
You see at the top of the transaction file checklist, it says closing in parentheses.
Mm-hmm.
Does that refresh your recollection as to when this particular checklist is used?
Used for closing.
And for the time that you have been contracted with McCormick Realty and Auction, have these checklists been in use or something similar to them?
Yes.
indicated, I believe, on questioning by the commission, that a contingency, you would normally include that in the special stipulations.
Yes.
You did include other special stipulations in this particular agreement, is that right?
Yes.
But you didn't put that one in.
No, ma'am.
Mr. Hall, it indicated earlier on direct examination that you were in a hurry.
Yes, ma'am.
Is that because there were other offers?
Yes, ma'am.
And did you intentionally leave out the contingency so
No.
that Mr. Dedrick would accept the offer?
No, ma'am.
I think that's all I have.
Bridal party.
At least it's not a pedal tavern.
I have nothing.
Anything? Okay. Members of the commission, does anybody have any other questions for Mr. Hall based upon these other documents that we've just seen? Yes, ma'am.
Ms. Taylor.
Mr. Hall, if you look at,
I'm sorry.
yes, I was handed an amendment to purchase and sale agreement, number 1. Well, let's see. Number 1, dated 5/26, to extend the possession date to June 3rd.
Yes, ma'am.
I was handed a second amendment, number 1, and is that office practice to have 2 amendments with the same number?
No, ma'am.
All right. In the second amendment dated number 1, which is buyer agrees to pay an additional $500, have you got that in front of you?
Yes, ma'am.
Who is that $500 to go to?
Mr. Dedrick.
And does that state it?
No, ma'am.
Franks.
I just want to make sure that I'm following this all correctly. So, the Walkers, so you had a buyer for their house, the Patels?
Correct.
Okay. And so the Patels being unable to close, you thought that you're going to be able to make the date, the original closing date.
Correct.
And so what you were telling me a while ago was they were having some problems getting their money. You said because they were foreigners or something like that.
But the problem was getting their tax records.
Gotcha. Okay. So you did have a buyer. It wasn't like you just thought, well, maybe a buyer will come along. You had a buyer and you had a contract, right, with the Patels?
I had a contract with the Patels.
Okay. Thank you.
Other questions? Let me ask just a couple of quick ones. In one of these exhibits that we've got here, the one that starts off with this Farrer and Bates letter, there is a document that says exclusive buyer representation agreement that's dated April the 12th. That would have been whenever Mr. Walker first came to see you and hired you to go sell his house and help him find a new house, right?
Right.
So this one says exclusive buyer representation agreement. Do you have was there another document that was signed at the same time that would have been for your representation of him as a seller? Because this one talks about as a buyer representation. Was there another listing agreement or other document that would have been for your representation of him as a seller of his house?
No.
Well, what's your normal policy on that? If somebody comes and they want to hire you to help them sell their house, do they sign something that says they've hired you for that?
Yes, I do.
Okay. And it's different from this exclusive buyer representation agreement, right?
Right.
So at the time he came in, you think you probably got him to sign a separate document besides this one that said you were going to be representing him to sell his house?
Yes, sir.
What do you do with documents like this exclusive buyer representation agreement and the other document we were just talking about once they're signed?
Put them in a folder, stick them in the files.
Okay.
Tell Mr. McCormick.
Okay. Thank you. Any other questions? Judge Stovall, back to you.
All right, very good. Thank you, Mr. Hall. You can step down. Ms. Palmer, your next witness, please.
Oh, Van McCormick?
Ms. McCormick, you want to come around, please, sir? Mr. Hall, why don't you leave those documents up there in case Mr. McCormick needs to review them, reference them?
I do.
Mr. McCormick, good morning.
Morning.
You have a principal broker's license? Do you have a principal broker's license?
I do.
How long have you had it?
Since 2001, I think.
You do own Van McCormick Realty and Auctions?
Yes, ma'am.
Where's that located?
404 Highway 76, White House, Tennessee.
Do you work in that at that business full time?
I do.
How many hours a week are you typically in the office?
It varies. I'm there sometimes from 7. I've been there till 10 o'clock. I go out and I list property too, but I know I spend a good 40 hours a week, or more than that, in this business.
How many agents do you have working for you currently?
9.
And at the time of the events in question, April, May 2016, how many did you have?
I would say 10.
And was Lee Hall one of those?
Yes.
You're familiar with the transaction at issue?
Yes, ma'am.
When did you first learn that there was a problem with this particular transaction?
It was June the 16th at about 11 o'clock, I'm guessing. Right, probably just prior to lunch.
How did you learn that there was an issue?
Mr. Dedrick called me.
What did he tell you?
Well, he told me, I can't exactly remember the words, but he was outrageous. It was just a rage. I couldn't answer nothing, and he just kept on. He says, "You know I'm going to sue. You know you're guilty. You know I'm going to do all this. You know I'm going to get your license. I'm going to get his license. I'm going to." He just kept on, and I said, "Sir, I do not know what you're talking about." He says, "You gotta know. You know." He was just extremely raging, angry.
All right. When you learned, did you learn from Mr. Dedrick what the specific issue was? What specific issue he was upset about?
Was that the contingency.
All right. And
It says, he just kept hammering me. Your agent knows that I would never accept a contract with a contingency.
as a result of that phone call, what did you do?
When I said, I'm going to get with my agent, this is right now, and I'll get back with you.
Did you get with your agent?
I did.
Tell me about that.
I called him into the office, and we sat down. I said, "You explain to me what all's been going on," and he proceeded to tell me, and all of these things with the Patels. The hold up on that, he was telling me. I asked him about what are you closing on the Dedrick deal. He says, "No, we got a problem with the lender, And I thought he's talking about between the Walkers, he's getting along. I thought that's what he was talking about. He didn't say it was the Patels. I didn't know about that he was having trouble with Patels.
Were you aware prior to May 26th of the closing date on the contract between Mr. Walker and Mr. Dedrick?
No, he hadn't brought his file in at that time.
Right. When Mr. Walker and Mr. Dedrick signed the contract, the agreement, purchase and sale agreement, did you receive a copy?
I did at that time of the contract when it was written?
Yes.
No, I did not receive it. He held it, he was holding it, and I didn't see it for a while, you know.
When did you first see the contract?
It was prior to closing, but it was not right. It wasn't on like April. In April, it was probably closer to the end of April, maybe, before I saw the contract.
When did you learn that there was a contract? Did you know before that? Or?
He told me he had a transaction. You know that he has a contract. He represents this guy that's going to buy a house in Old Hickory, I believe it was. And so he told me about it. I said, well, I need to get your file, you know. And so that's when I knew about it.
On the date the contract was signed, you didn't see it?
No, I did not see it on the day it was signed.
When you did see it, what, if any, procedure did you go through in reviewing it?
I looked through it, and of course I filed it. I looked through it just to check it, to make sure the signatures are all on it, and the dates are on it, and that everything looks like it should.
Did you notice anything missing?
No, I did not.
Did you have any conversations with Mr. Hall at the time you reviewed the contract about the contract and the terms of the contract?
I don't know that I did go over that with him in his presence, but I did look it over, you know.
And did you have occasion to, well, how do you keep track of when a particular property is scheduled to close?
Well, it's in the paperwork, and usually on the outside of the folder, you know, I make a note of it that it's going to close on that day.
Right.
You know, I don't have a 100 agents. I probably would do a board if I did, but no more than we have, and no more closings. I can.
How many closings has your firm done this year so far?
We haven't closed anything this year yet.
How many do you, on the average, if you're able to estimate, how many transactions your firm engages in a year?
I would guess 25 or 30. Probably 2 a month, 20, maybe 24.
And in those approximately 2 per month, you indicated that you would write on the outside of the folder what the closing date is.
Yes, ma'am.
Do you check those folders as time passes to keep track of the closing dates?
I review them, yes. But I usually don't have in my mind when they're going to close. If it's, you know, with no more than that is, I know when it's coming up, you know.
Did you receive from Mr. Hall any information regarding the closing date being extended?
He mentioned to me that they were going to be, you know, they was going to have to extend it. They were having trouble with the lender. But the lender, it was another's lenders. What I was assuming he was talking about, the Walkers, you know. Yeah, he told me. But now, he kept that in his folder. I don't think he brought me that extension in at that time. I think he held that in his folder.
Why did you assume that it was the lender for Mr. Walker?
Because he just says, we've got to extend it. The lenders, need some more information.
Did you know at that point that there was even another lender involved?
Not that I know of, no.
When you received did you receive the amendment, the first amendment dated May 25th from Mr. Hall?
That amendment, did I receive it?
Yes.
I did not. He held it in his folder. He kept it.
All right. Well, if that's the case, then when closing approached, what did you think, knowing that there was a May 31st closing and not having an amendment?
Well, he told me. He told me that it wasn't closing, that we were doing an amendment.
All right. Did you ask him for a copy of it?
I don't know that I asked him for a copy of it right then. I don't. But he said he was doing the amendment, and I trust him that he was doing the amendment.
And have you had any similar problems like this with Mr. Hall before?
We've had a lot of questions. We've gone over some things that he's had questions about before, and clarifications on some things. Yeah, I've worked with him on those on just as a need be basis outside of when we have a regular meeting or something.
Did you learn what date the closing was extended to?
Yeah, I think he told me they were extending it to the 3rd, at the time, and I said okay, and then he told me he's going to extend it again.
Did you ensure prior to the original closing date, May 31st, that there was an amendment extending it to June 3rd?
Yeah, I asked him that. I said, you make sure you got your amendment done and do it before it expires, the contract.
To the best of your knowledge, did he do it before it expired?
I've never had, I really haven't had, we haven't really had that much issue. I've never had anybody to call, nobody to complain. I've never had one before. And usually he's done, okay, all his paperwork turns out correctly. And of course, he calls me if he's got a question about something. Usually, but he didn't on this.
And was there a second amendment?
Yes.
And did you ensure that the second amendment was executed prior to the June 3rd closing date arriving?
Well, I assume that he knew that. I've done told him, I said, if you're going to do an extension, just make sure you get it, you've got to have it in order and on the right dates. You've got to have it before this thing expires.
All right. Well, prior to the first amendment expiring, making the closing date June 3rd, did you ensure that Mr. Hall had a second signed amendment extending the closing beyond June 3rd?
Yes.
Okay.
I did not.
Did you have a conversation with Mr. Hall about why there was a second amendment?
Yes.
What was the gist of that conversation?
There was an issue with probably underwriting. They needed some more documentation from the buyer.
Identify the buyer? Which buyer he met?
No, he didn't. I just assumed it was the Walkers. He's helping him buy this house, and that was the transaction that he was referring to.
Did he tell you at any point during the period of time from the First Amendment through the Second Amendment that there was a contingency on the sale?
No.
Did you ask him?
No, I don't think that I asked him.
Would you have had any reason to ask him?
I didn't think so.
How long has Mr. Hall been working with you?
Since 2010.
How many properties would you say he's closed in that period of time?
I would say about maybe 10. Just guessing.
When you learned of the contingency and what the issue was from Mr. Dedrick's call, had a conversation with Mr. Hall.
Oh, yes.
What did you tell him?
I remember exactly what I told him. I think I asked him some questions. First thing I said, are you crazy? That's probably the first question. So what if you, are you crazy? You know, there's a contingency. Has this thing got a contingency? You didn't put it on here? I said, you are crazy. You know, and we wound up that afternoon. I says, you're going to make this thing right. I hate it. I hate it. I really hate it. It's not the way I do business. And he tells me he forgot it. And that's all he can tell me. He just forgot to put it on there. And then I said, well, we're going to call. We called his agent. You couldn't talk to this other fellow. I didn't feel like He said, he kept saying, I'm going to go ballistic. I didn't know what he's going to bring, an assault rifle or what, come to our office. But I said, call his agent. You know, you got to make this thing right, whatever it takes to make this thing right. You've got it. If you're going to have to buy his house, you buy his house. And I think he was going to buy the Walker's house so he could go on and close and give him whatever money that he had, you know, or was asked. I said, well, how much can you give him? And he said $25,000, you know. And so he called the agent and offered to do that. The other agent said, well, he's not going to do that. He's got a backup contract. You know, he already had another one in place. And when that didn't happen, you know, I don't know that there was anything that we could do to please him. And then he, in this letter that he wrote, I think the Dedricks wrote, saying that he was almost lost $18,000, I think, on a house he was buying. Of course, he was a real estate agent or a real estate salesperson, I think they called him, in New Jersey. And I would think he would put a contingency of the sale of his house in it. I don't know how he could have almost lost it. But he embellished some of the stuff.
Let me just be clear. Are you saying that Mr. Hall offered to purchase Mr. Walker's house so that Mr. Walker could close with Mr. Dedrick?
I think he was going to purchase Mr. Walker's house so Mr. Walker could purchase Dedrick's house.
And pay him $25,000 on top of that?
Well, he was going to give $25,000 probably down. We'd have to work it out on paper to Walker, and it would be non-refundable so that he could go on and give Dedrick that $25,000. He would not be obligated to hold it in escrow, because you give $25,000 and it don't work out, you've lost $20,000.
I spoke with Mr. Hall about his mistake. Talk with him about anything that he should have done, any procedures in your office that he should have followed that he didn't follow that would have prevented this from occurring.
None that he did not already know, because I've gone over with all our agents about being sure that checklist has stipulations on the bottom of it from the check. I tell them, be sure to go over the contract real good. Talk with your client, go through the contract, make sure you cover everything, make sure you don't leave unchecked contingency on financing or contingency on the sale price being equal, or the appraisal being equal to the sale price or greater. Be sure if you've got any addendum, if you're going to do an FHA, you got to have your FHA addendum. We've gone over that, and I give every one of them a folder with both of those checklists in there. And as I went through the checklist, I said, this is the way that you start out. And most of them do, but maybe a couple like maybe needed, in case they had anything in question. The first thing you do, on line number 1, there's 2 check blocks on there. You're either going to check one or the other. You're either going to be a listing agent or you're going to be a buyer's representative. And you're either going to be listed, the top, there's 2 columns on the side. You're going to be representing the buyer or you're going to be representing the seller. It probably says listing. You're a listing agent or you're a buyer's agent. And you just check those down through there.
Are you referring to the transaction file checklist? That's
it. And I tell them, hey, you go with this as you sit down filling out your paperwork. It works both ways. When they're through with it and they bring that whole folder into me, I check the whole thing. If there's something that isn't right, they don't get paid till it's made right.
On the checklist, I notice at the bottom, line number 23, it says special stipulations. Is that what you were referring to?
Yeah.
And what do you instruct the agents regarding contingencies when they receive a transaction, when they have a transaction and it involves a contingency? What do you instruct them regarding where they're supposed to record that?
The contingencies. Well, if it's a contingency that's outside of the ones that's in the contract, the standard part of the contract, you put those in special stipulations. And they all know that. And there's no reason why any of them shouldn't. It's been told many times. They fuss about us going over contracts, some of them have. But that's part of it.
How often would you say your agents are trained or on contracts or issues regarding contracts are reviewed with them?
We'll have one probably next Thursday, because I'm scheduled to be, and I may not make it. My wife is going to be there. They're in Springfield. In our association, they're meeting at 1 with Todd Schulter's going to teach the class on all the updates.
Okay.
But we're going to go over that. Yeah, we're going over them again. We're going
Prior
over
to
the
Thursday,
changes.
Prior to Thursday, when was the last time that your agents would have been trained or reviewed or had contract issues reviewed?
Probably October, probably. It might have been September, but we touch on them. We had a thorough one before that.
All right.
We had one right after, this complaint, for sure. Just because of it, I said, guys, you don't think some people, I don't know.
Did Mr. Hall provide you with a copy of a contract for the sale of Mr. Walker's home to the Patels?
No, he did not. He held that in his briefcase. He didn't bring that to me.
That's the one that he held, the Patel Walker contract?
That's the one he held. Yeah, and he held those extensions on the Walker buying the Dedrick home. He had those. But he told me, we did talk about it. I was, well, make sure you got it. Do you understand what you have, how to do this? We did talk about it a little bit. But I did not receive those particularly at that particular point in time. And the one with the Patel that he listed, he entered in the MLS, and I saw it in the MLS. I said, hey, where's my paperwork? Did you list this house? Yeah.
Get the paperwork after that?
I think so, yeah. Got a copy of it. Yeah.
Are you able to locate the specific transaction file checklist related to the Walker Dedrick sale?
I don't know whether he had filled it out or not, because it never did. He didn't close. And do we have it? You've asked me a question. I would have to look back and see before I could really truly answer.
The documents that are in front of you include the. Did he not leave those?
I drop them or something? Huh? Okay.
The transaction file checklist, which was at the top of that pile, is that the one that is supposed to be completed when the contract first comes in?
No, it doesn't have to be completed when they first bring me their copy of a contract.
Okay.
I file the contract, but they may have one in the folder, but they don't have to. But they should have this and document. I've instructed them when they go down to where the number 7 is a binding agreement. I said, when you get to binding agreement, make sure use this one. Because you've got timelines, we've got new rules that have changed with CRED, and you've got waiting times between before closing. Right after that you sign a contract, you've only got so much time to do things. This explains it. It helps you, and we've gone over those things. But this has to be in a file when he brings it. When they do the closing, this has got to be in that folder and filled out. And it doesn't have everything on the TR forms. They're not all listed, but these are the main ones. There's always could be some more, and that's why those blanks are there. But these are the ones most prevalent that you run into. Up here, I guess it's take line number 6, where counteroffer, and you come down to line number 8 where you see amendments. There's a place there they can have 1, 2, or 3 amendments, and this is my checklist. I did this myself as the broker, and there's questions there. I said timeline compliance checklist for purchase and sale agreement. It says, I got out in the parentheses, and I've told them all, print, at the binding agreement date. That's this one right here, timeline compliance checklist for purchase and sale. That's this one. Because you need that. That will help you make sure you're on track.
Now, you indicated that a contingency on a purchase of another home, one that's not in the purchase and sale agreement, a contingency on would be included in special stipulations, right?
Yeah, well, they would check it. They may make a note on their contingency of sell a home.
Right. And you would know about that contingency because you would see it on this form. Is that right?
That's right, if I have the form.
Well, okay. So is it a policy that your agents have to put this checklist in the transaction file that you hold?
No, I don't have that as a policy of the one that I hold, but they have this and they know to use it, and it should be to keep everything correct, and maybe that I should have that as when I get my folder that they can just do another one, make a copy and continue, because this thing is there's a lot of things that could happen, amendments and things, and it wouldn't really show them all if they brought them in to me right after they're getting a contract.
Do you have any, I'm going to say red flags prior to this transaction with Mr. Hall that would have caused you to give any extra scrutiny to his transaction files?
I don't know that I had any. No, I've never had any specific red flags. I've never had any agent or myself have any issue with a contingency.
What did Mr. Hall tell you regarding why he failed to advise you of the contingency in the contract?
He just was embarrassed. I think he did go ahead and list the Walker's property, and a few days after he listed it, he got a contract, and this is telling you from what I now know, and that it was going to close the same day. It was going to be seamless. So he could have done it all, got it all done, and come in with his folder and everything fine, and deposit the commission check. We'd do all of those kinds of things, and wind it up. And I probably wouldn't know that there was a contingency. It wouldn't have never been an issue.
Other than what we've talked about, are there any procedures or safeguards that you use in your office to ensure that documents are completed properly and transactions flow smoothly and go to a successful closing? What are they?
This list right here is the main thing that I use. This one and this one right here, but we go through the forms. They take classes on forms, and those are the things that are important. And as they go over the contracts, they should know all about the it's 10 pages to a contract now, just a residential contract.
Do you have any doubt that Lee Hall understood his duty of due care to his customers?
I don't have. He knows. He says he knew, because I asked him again. Says, don't you know that you have to put a. Yeah, I know it. I know. I already knew that. Just forgot it.
Has Mr. Hall, to your knowledge, ever had a complaint filed against him before?
Never.
Has the firm or you personally before?
No one in my firm has ever had a complaint that I'm not done on my watch that I know of. I don't know that they ever did before. There are 4 brokers in our office, and one I've downgraded that was active to just an affiliate. Of them, they're real conscientious for the most part. Got a couple of them that they know, but although they know, you need to. That's why you have meetings. That's why you go over things, and I tell them probably the most important thing, in my opinion, is to making sure you got to know what you can't do something if you don't know what you're doing. And I tell them that the core course, the ethics class, I said, you've got to go by the golden rule, So, and I point the golden rule out a lot. I says, and what especially, if you leave out that contingency, and here's somebody that's they're in a bind because you've done something, and I'm not saying, all I know is he told me he just forgot. Whether that's true or not, only God and he knows that. But it's hard to believe that you couldn't at some point want to get help. I think that, but I do believe that he probably was scared. And he probably thought it was going to work out if he got that other contract. I'm just guessing that that's what happened. But if you have a contingency and you don't put it in there, and I've got to move, and you can't close because you had a contingency I didn't know anything about, would you want that to happen? Would you like to be sitting on the side of the road with all your stuff in a U-Haul truck, and you can't close your house, and you've got to move? I've seen that happen. I've seen that happen without any contingencies, just because of lenders.
Mr. McCormick, have you received any honors or awards in connection with your work as a principal broker?
I'm objecting to the relevance.
Maybe it goes to intent because.
Rule. Go ahead.
Yes, I have 3 award of excellence that I could have had 4. I just didn't turn it in. Had one agent. She was a broker, that didn't want to turn hers in. She had it last year, had one. I have done, just things for civic organizations, done a lot of auctions for them, and we've received I guess an honor award, a beautification award from our city for our office in the past, and
and how long is Mr. Hall's independent contractor agreement with your firm? Is there a beginning and end date, or is it forever until you?
I think it is until either one of us decide to amend it or that's agreement, until we do another one, amend another one, or do another one.
What action, if any, did you take with regard to Mr. Hall after this incident occurred and you learned what he had done?
After that, after this incident, we had several long talks about this business, about his duties that he owes to clients, duties he owes to all parties to the transaction. He knows all of that, but I'm reminding him all of that. I'm reminding him of how important it is. And I'll tell them all. I said, when you're dealing with doing a transaction, somebody's going to buy a house or they're going to sell a house, you're probably dealing with for the most part, 90% of the people, that's their number one investment they have in their whole life is in their house. It's extremely, extremely important. I never dreamed I would be here today. I hate being here today. I love to be here to meet you. I'm glad that I did not know there were that many brokers that have received disciplinary actions, but sometimes I know one thing. It sure hasn't really. I've known all these things, but how extremely important it is to try to get your agents to do right. You can't. The thing of it is, they're independent contractors. You can have a meeting. You tell them, they may not show up, and they call you and say, "Well, I've got this to come up. I've got a doctor's appointment. I've got a." Because sometimes maybe they probably do, but it's.
What do you understand your duty to be with respect to supervising your agents?
Oh, my duty is to make sure. I believe my duty is to make sure that they understand and know, and that they do have a care. I want to make sure they go with this golden rule. That's tops. Don't do anything. Don't try to cheat. Don't try to do something for your advantage. Somebody that, in my opinion, that would do what we just had experienced. The only reason they would do something like that, if they did it intentionally, it would just be because they're just greedy. It's all about me and how much I'm going to get a commission. That's what that would be. But I believe in I with Lee Hall, I'm not saying anybody can do anything. But that's not his character that I have seen with him. And I don't see that with any of the others. But we'd have a serious talk if it was.
From the perspective of the Brokers Act, the Real Estate Brokers Act in Tennessee, and the TREC rules, what do you believe your responsibility to be in terms of supervising your agents?
Make sure they have the tools that they need to work with. Make sure that they understand their duties. Make sure that they have the training that they need. And we do that. And we make sure that they understand their paperwork that they're dealing with, and all the procedures that they're supposed to do in a timely manner.
Do you feel that you have fulfilled that responsibility?
Yes.
Is there anything that you believe you could have done differently in this particular case to prevent this?
No. I mean, I didn't have any knowledge of what happened till I was hit. I mean, man, I've never had a phone call like that. Nobody's ever called me or about anybody in my office. I've never had anybody call and complain.
Do you understand why Mr. Dedrick was angry?
Oh, Lord, yes.
Okay. I don't have any other questions.
I just don't know. I'm so sorry about it. I wished I did know. Wished I had them done.
Thank you,
I
sir.
don't, and I'd have to go out with every agent on every call and sit down and ask the buyer, or call the buyers or the sellers on the other side. I mean, there's a limit to what you can physically do as a broker.
Thank you, Ms.
Thank you,
Palmer.
sir.
Ms. Ryan?
Yes, do you review the contracts for listing agreements when they come in your office?
Yes.
But you didn't see the contract for the listing agreement in Mr. Walker's home?
Yes.
You did see it.
Oh, yeah, but he didn't bring it right into me.
Well, did you
it.
see that before or after this whole issue came up with the contingency issue of the sale? Did you see the listing contract before that?
Before the contingency?
Did you see it before this contract we're talking about failed? Did you see the listing contract before that? Was the house listed
It's
before?
possible. I think that the best I remember, that I looked at MLS, and I saw that, and he told me he was going to sell their house, but I didn't think that much of it, because a lot of people, and I've had them
Hey,
do.
let me just ask you the question again. Did you see the listing agreement to sell the house for Mr. Walker prior to the failure of the contract in question?
I believe it did, yes.
And why did that not ring a bell in your head that, hey, there's a house to be sold and he's buying a house? Why did that ring a bell in your head to say, hey, is there not a contingency, maybe, Mr. Hall, that this house has to be sold first? You didn't ask him that?
I don't know that no, I don't think that I did, because he didn't have a contingency on the contract.
Well, I understand, but isn't it typical when you've got a house to sell over here and you're buying a house over here? Isn't it often that it comes up, ding, 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 this house has to sell before there's money for this house to buy? Isn't that
Sometimes,
common?
Not all the time.
Doesn't it happen enough that shouldn't that ring a bell with you overseeing your office and what goes on, that, hey, is there a contingency here?
I looked it over, and I'm not, the listing agreement, I looked it over, and I don't know that I looked at and focused that much on the name.
Well, but how many? But you just said that he's only had about 10 transactions in the last 10 years, though. Wouldn't you have thought, since you knew it was him, that, hey, that rings a bell about something that he's already had? He just said he didn't have that many.
That's true.
Well, why didn't it ring a bell that it's something you should have checked on?
Because I didn't see any contingency on his other purchase agreement. There was no contingency on it.
Okay, and you said earlier that all the amendments to the contract, you didn't see any of them. He just told you about it. Is that right?
He held them in his file.
Well, why didn't you ask to see them?
Because he would probably bring all that in together, and when he did his closing, and it would all be together.
Why isn't there not a procedure in your office that when there are changes to the contract and amendments drafted, why they are not presented to you prior to anything else happening?
A lot of times, I usually get some of this by email. You know, some of the agents send it in by email.
Copies of the amendments?
Yeah, any other thing that may happen, or the transaction itself.
So why didn't you ask to see a copy of the amendments in this particular case?
Well, I trusted him that he knew what he was doing. We went over it.
Who is the principal broker, sir?
Who's the principal broker?
Mm-hmm.
I am.
And aren't you responsible for all the actions of your affiliates in their working with people in this business? Aren't you responsible to be overseeing them?
I am.
Okay. Wouldn't it have been your responsibility then to make sure you saw copies of documents and not just trust someone saying there is a copy of a document? Shouldn't you be looking at every document that's signed and not just assume it's
Eventually
signed?
I do.
But you didn't look at any of the amendments in this case, did you?
Well, he hadn't brought them in to me.
You didn't ask to see them.
I don't know that it did, but we did talk about them, as I said before. I told him.
Do you not ask to see all the copies of every document that's signed? Are you not asking to see copies of signed documents, whether it's the original contract?
I do see them all.
When they are signed?
Well, not the minute. No, not.
But
right
if you
when they're
know there's a
signed.
change, for instance, you said earlier that you know in your mind the date something is going to close. I would think that would also ring a bell in your head, and that you would ask to see. You don't ask. Okay, but you didn't ask to see any of the amendments.
Yeah, he said we're going to extend it.
You didn't ask to see any of the amendments.
And I told him, yeah, well, you're doing the amendment. And we went over that, you know.
But you didn't ask to see any of them. You did not ask to see any of them.
I'm not sure that I didn't ask to see them.
But you didn't see them. You did not insist on seeing them.
I don't know that you know, you've asked me a question that, you know, we see a lot of stuff every day, and I don't know that I.
Well, I understand, but you said you had 9 affiliates working there, and that Mr. Hall's only had about 10 transactions in all these years. Wouldn't that not say, hey, maybe I need to be looking at this, since it's only been one every so many years?
Well, I did. I have looked at his. Yes,
but you didn't look at any of the extensions.
Well, this is everything had been going out. Never had any trouble with what he had done before.
And you didn't see a copy of the listing agreement until you happened to see it in MLS that somehow you all were listing a sale belonging to somebody. You didn't see it till then, right?
I don't think I did. No.
Do you not have a procedure in place that when someone lists a piece of property, that copy of the listing agreement comes to you immediately?
Oh, yes.
But it didn't happen.
Not in this case. You know, I think when I saw it, I said, "Hey, I see you've listed this. I need your copies of this listing agreement."
And you said you were in the office about 40 hours a week. Is that correct?
That's correct.
Do you know what your legal, according to the rules and laws of Tennessee, your legal responsibilities? Can you tell me the absolute legal responsibilities of a principal broker? Do you know what you have to do?
Well, there's a lot of rules.
As far as a principal broker.
Well, I'm to supervise.
Well, let me ask.
To be responsible for the actions.
Okay. Well, let me ask a particular question. Are there any responsibilities of principal broker for things like advertisements?
Yeah.
What?
Well, the advertising, the rules say that if a person's going to do an ad, then I've got to see it and I've got to approve it.
That's for your affiliates.
Things, of course, they change, and every time they change stuff, I usually look at advertisements because sometimes their names could be as big as mine, and some that can't be as big, and can't be as bold, or can be as bold.
And what else is exactly outlined specifically in the laws and rules concerning overseeing affiliates? Do you know?
That they do their paperwork in a timely manner.
You know any of the exact rules and laws concerning the responsibility of a principal broker besides advertising for the affiliate? Are you aware of what E&O is?
Yeah, they have E&O insurance, that's true.
And what else do you have to know about E&O insurance?
That they have their E&O in place, and I have a copy of it. And the E&O is insurance is required. They cannot let it lapse. If they let their E&O lapse, then they're not protected for anything from the time past till the day that it lapses. They've lost that coverage. They lost that continual coverage.
What else happens to them if
Well,
they don't
get
have
fined
it?
by the state. I mean,
What else can happen to them?
Well, they could probably lose their license.
You don't know? You don't know what happens to an affiliate whose E&O expires?
Well, their license are obsolete.
Brian, let me interrupt you a minute. I think we're kind of getting off the track here.
Actually, I was trying to get to the rules and responsibility of a principal broker concerning affiliates, and I'm in my point of my questioning is to say what I'm trying to say is that I'm not certain this principal broker understands all his obligations as a principal broker. That's where I'm going on that.
Well, I understand that, but let's focus on the transaction here that Mr. Hall was involved in. That he has not been charged with lack of overall supervision of his of his office. He's been charged with lack of supervision over Mr. Hall in this particular transaction.
That's
so go
correct.
ahead, Ms. Ryan.
Okay. Do you have an internal procedure in place that you go over with your affiliates prior to any closing?
Yes.
What's your internal procedure?
I see a copy of it before closing.
And do you ever go over it and ask if there's anything in the contract or any issues that might come up?
I look them over and I ask them, if everything's complete? Have you looked it all over? Have you gone over it with your client? Is everything like it should be? You know.
You do that for every closing?
Well, sure.
Okay. And you had mentioned earlier that a checklist is provided to your affiliates to check when they're drafting the contract, but you don't get a copy of that every time there's a contract that comes through? You don't look at the contract checklist?
When they first start generating, and if they're meeting somebody or they've been showing a house and been looking at the houses, sometimes they want to write all that stuff up right there at the house, and they do all that, and they bring it in, make their copies, make my copies, put them in a folder. But they usually, I'm not saying that some of them don't leave me a copy of what they've done so far. If they're using this, some of them already know well enough that that are seasoned enough that they could write this for them. They know it.
Was there one filled out in this particular contract by Mr. Hall?
Was one of those filled out? Sure.
And you reviewed it?
When it didn't close.
I didn't ask that. I asked if you reviewed it. This is a transaction file checklist. Did you review that?
If it's in his folder, I did.
But you don't know.
Well, I don't know what he put it. It was in his folder. It was in his folder. Yes, I do recollect it being in his folder. Wasn't complete because they hadn't completed the transaction. They hadn't done a closing, and they don't have a copy of a commission check. Don't have a copy of a few things there.
And you said earlier that you think the addendums were in his folder. Is that right? The addendums to the contract?
Yes.
But you didn't see them, but they were in his folder.
Well, I didn't see them at that time. I've seen them. Yeah, I've seen them, but I didn't see them before the 31st of May. You asked me, I think.
I have nothing further.
Or anything else? Yes. Briefly, thank you. Members of the commission, questions for Mr. McCormick?
Ms. Hills.
Mr. McCormick, you testified that the size of your office was about 9 or 10. Can you give me just an estimate of about how many listings you have in your office usually? Just
right now?
Just an estimate.
I think we're at the present moment. About
Yes.
3 right now.
3. Okay. All right. And who owns those listings?
Who owns the listings?
Yes.
Well, the broker.
Okay. All right. We don't have a copy of the listing agreement in our package, but in your company, do you practice designated agency?
Yes.
Okay. And so you did have Mr. Wilson's house listed, property listed?
Yes, we did.
Okay. You had testified that that Mr. Hall, just a few minutes ago, may have held the purchase and sale agreement for a while, possibly, and it was binding April 15th, 2016. And I noticed that the binder, the escrow monies, is to be deposited within 3 days. Now, it's to be deposited with parish, which is a little different from our area, and which is every area is has a customary that's different, and that's fine, certainly. how do you know in your area, since it's different from my area, how do you know that does Parish notify you that they've received the binder within that 3 days? Because I would assume Mr. Hall then delivers the binder to Parish.
Parish.
Well, that's the name of the company, evidently, the other company? Or do you hold the binder? I was just looking at the purchase and sale.
On that one, I deposited that earnest money.
Oh, on the purchase and sale, it said that Parish and Associates on Lebanon Road, Mount Juliet, was to hold the earnest money.
That was for the sale of the Dedrick house. That is true. Yes.
Okay. So on that, how do you know that so is Mr. Hall the one who's to carry the Wilsons' money over to Parish? Is that how it happens? Because it's a little different from my area.
Yeah. I would say that probably, I'm guessing, I don't know, Lee would take that probably to Parish, and he would take a form. We have a form that they sign that they've received this money on this date, and whoever received it, if it's a secretary that is, they sign they received it on that date. Because it might lay there 2 or 3 days before they deposit it, because I make them do that. I said, because, if you got a buy-in agreement date, and you've got down here that's going to be deposited in so many days, a buy-in agreement date, if it says 3, you've got to have it there so they can deposit it within 3 days.
Right, because the contract says that it can be null and void if it's not deposited into Parish within those 3 days, correct?
That would be correct.
Okay. So you're not sure if we really had a contract or not, just the way this is going. I'm just wondering. So on the Exhibit 1 that we were handed on page 4, it said in your McCormick's affidavit, it said, as required by VM Realty and Auctions, Mr. Hall provided copies of the purchase and sale agreement, Amendment 1 and Amendment 2 to VM Realty and Auctions. These documents were reviewed and maintained in the office, and this is McCormick's affidavit. So you were saying the purchase and sale, you received them and maintained them and reviewed them in your office.
Well, I would be corrected then. If I probably did, and I just don't remember receiving them. But I probably, if I put it in there, I checked it and I knew that I did. I wouldn't put down that I received them if I didn't.
When it comes to extensions, then, and they go in, certainly brokers nor agents. We're not attorneys, and we don't practice law, and that's why agents come to brokers or depend on brokers for help when they're doing wording on amendments. And that's usually the time that the brokers will ask the agents what's going on, what's the problem, because a lot of times we can help them resolve the problems, and not only with our situation, but we may be able to help them with the sale that's in front of it.
Right. That's true.
And we're usually the more experienced ones that we have to pull it out of them like pulling teeth, and we have to listen for things. I tell my husband all the time they may misuse words like offer versus contract and things like that, and we have to listen to every word that comes out of their mouth so that we ask the right questions back. So do you often try to help and problem solve and be involved, or are you just...
I do, yes. I do with some, and there's some there that probably has been in, have had a license even longer than I have that do an extremely good job. I mean, extremely good. They know they know everything. I don't ever find any. Very rarely will I ever see probably maybe a missed signature or something, especially like on a. Usually it would happen maybe with a termite letter, and they get it and stick a copy in there. Well, when you close the file, it's supposed to be. It needs to be signed too, by all parties to that transaction, to the buyer and seller both. Stuff like that they'll do sometimes. They have done. Those are the kind of stuff that I say, hey, you get this done, and I say I want to see everything before you go to closing. We're going to sit down here and look, because what'll happen is they'll go to closing. If I don't watch them, sometimes they'll forget the walkthrough. Yeah, he said they didn't want to do a walkthrough. Well, you need to put this on this you got to put this on the form, the walkthrough form, that they opted not to do it, and let them sign it. That needs to be it's got to be in your file. So that's usually where the biggest things are. Contracts we've gone over, I think pretty much everybody knows.
Or the domino. So even Mr. Wilson's house selling or closing with that buyer before, it could have a domino effect. So it.
Oh yes.
Contingency or no contingency,
Right.
It could have a domino effect. Okay, thank you.
Mr. Horn?
Yes, sir. Sir, I'm what we call a public member of the board.
Okay.
So what I'm saying is these people know all the contracts and what belong in each block and all that. I don't pretend to know that. But there is two questions that stand out in my mind. I'd just like for you to answer them to the best of your ability. And number one is why didn't you demand to see the contract? You told 2 or 3 times that, well, he might. It ought to be, well, okay, you understand what I'm saying, right? Yeah. Number two is their folders where they put all the stuff in that you was talking about.
Yes, sir.
Is it also a privilege to you? Can't you ask to bring in your folder and come in and sit down and explain what you got here?
Yeah, I do.
Okay,
but
that's what I'm
usually with everything with agents that have been there and have done enough transactions, you feel like bring it in. I need to see it. Some of them I've told them, I said, hey, you need to come in. What are you doing tomorrow? You got to come back. Well, some of them I think they've done that from before at other places. They will. Some of them have a tendency that you've really got to bear down on them, and I have. That's my job.
You're missing one point. I don't mean will, but policy is when you write a contract, bring it in and let's talk about it. That's what I'm saying. Would have kept us from being here today.
You're exactly right, and that's what most time we do. And nowadays with the new electronic transactions and everything, that copy comes to me. I could see that. In fact, I'll pull it out, print it, and put it in a folder, and put it in a file for them at the office, and look them over.
Mr. Bloom.
Mr. McCormick, thank you very much for being here today. I'm thinking that's not the place you want to be.
No.
But I do sense your appreciation and respect for this business and the way you've given testimony.
I appreciate this.
I only have one question. Can I give you a couple dates that I've written down? The contract was written on April 15th. It was to close May 31st. Then we had an addendum on June 1, to extend the contract to 6/10, and it didn't close on that day. At what date did you receive the phone call from Mr. Dedrick?
On the 16th, the day that was the last set date to close.
That was the first time that he knew that there was a contingency not stated in the contract.
That he knew that Mr. Dedrick.
Is that the first time that he knew?
I believe he knew that on the 31st. He knew that. I didn't know that. Because Mr. Lee Hall, the agent in this case, he had to tell the other agent hey, we can't close because we got a problem with the lender. You know, he tells me we had a problem with the lender, but I thought he was talking about Mr. Walker, the buyer, because he was getting the loan.
But when he negotiated this,
But he was
addendum,
talking. He was referring to Patel's the Patel's loan, and the underwriter needed documentation of his income, and I think they were using the IRS his tax records where he filed his taxes to get. I don't know that all of them do that, but this was U.S. Bank in this particular case, and the lender that was working with that agent, that buyer's agent, the Patel's buyer, Mrs. Dow, she was being told, well, we'll have it in 3 days or 4 days. We'll have it. We're just waiting. It's got to have this done. The underwriter's going to sign it. We're going to be able to close. And so I think when the 31st came to Denton, Lee Hall, you know, he had to face the music with the other side with the agent representing Mr. Dedrick.
Mr. Dedrick, phone call to you was on the 16th.
Oh, yeah. It was at the third, I think the third extension.
First time he knew about it.
The first time he knew
Was
about
that
it?
the first time he knew that there was a contingency involved? Or
He
involving
agreed. He signed the extension 3 times. He agreed to that 3 times. But this third time, you know, he didn't. And probably one of the reasons was he already had another backup contract signed and ready to go. And but it was the first time I knew about it. It's when he called. And it was not a good day. That was probably the worst day in my brokerage career, to get a call like that. And it's just devastating. And I really feel for him. I really do. And
thank you very much.
Yes, sir.
Ms. Taylor.
Yes, I would like to know, you said you had the contract in your file, correct?
Which file? Which contract?
The James Walker to Dedrick. Actually, in the purchase and sale, there is not a seller's name on the main sheet. It's at the end, and I can't read it there. But I think it's Dedrick. That's Dedrick.
On the Dedrick file.
Mm-hmm. Tell me again when you said that was put in the file. Do you know?
Not exactly sure. He did not bring that file in to me immediately, but we did put it in a file.
And would you say it was 10 days or something, within 10 days?
Probably could have been 10 days, yeah.
Yes. And so when he puts the contract, when he put it in the file, what is your procedure once it's brought to you?
Well, I look it over, and then I put it in a file. And in that file, and, you know, if there's something on there that needs to be corrected, if there's a name missing, I'll tell him he needs to correct it. You know, he needs to get that corrected. He needs to do whatever needs to be done. If it's not there, I'll tell him to make sure you got this part right. And then I put it in the file. I put a list in a file. And I hold it, when it closes, I put it in where it's locked. It's in a locked office.
You do realize there's no seller's name in the purchase and sale agreement then?
There's no seller's name?
Correct.
At this point, I don't recall. If I did, that's over 2 years ago. I probably told him to correct it. I don't know exactly. You asked me something that if I looked that over and saw that there, I would definitely tell him he's got to have it complete.
But so if he put it in there and you saw it or didn't see it, what's the procedure for changing it if you saw that there was no seller's name in there?
I mean, he would have to have. He's got to have the seller's name in there.
And what? But if you once you tell him that, how do you check that the seller's name gets in there or there's a correction made?
Yeah, well, he would make that correction, and he would, and usually the other party, he needs to notify them. I'm going to put your name. I don't have it in here. you know, that day he says he was in a hurry because the agent had told him, if you'll hurry up and get this contract over here, we'll get it done. If you bring us full price offers, says, we'll get you a binding agreement on this.
Well, when he
and
brought
I think
it
he
to
hurried
you,
through that.
well, when he brought it to you, were you in a hurry also?
I don't think so.
Well, now you said that you did not see any of the amendments until what time? When? The extensions, I guess you'd say.
He held them in his folder, and they were going for one, waiting for the next one. Usually, it's going to close. Just bring it all in when it's completed. With him holding the amendments, he executed those amendments. He's got those amendments, and there's no closer going to close without those amendments.
All right,
I mean, we all know that.
What I'm saying is, when did you physically see
The amendments.
The amendments as he wrote them and they were signed? When did you see those?
It could have been the 16th on the afternoon. I told him to bring everything he's got, every email he sent and received, and I want to know everything about it.
Well, all right. So can you answer the question for me? This is on amendment number 1, which is really supposed to be amendment number 2. You have number 1 amendments and one number 2 amendment, which number 2 was not signed.
I very specifically remember that, and he was changing the number on that amendment. It should have, and he should have got with the other agent to do that, and that was to be the one that closed on the 10th.
10th, yes.
Yes, that's the one.
The one that says it's supposed to close on the 10th, did you see any other issues with that amendment?
I mean, you asked me a question that's been a pretty good while back. I just cannot recall. I don't want to tell you a wrong answer.
I'll tell you what it says, and you tell me if there's an issue.
Okay.
Buyer agrees to pay an additional $500 plus forfeit the earnest money of $500 already paid to Parrish and Associates in the event this transaction fails to successfully close on or before June 10th, 2016. This agreement is to be paid outside of closing by the buyer in the event buyer is unable to close on or before June 10th, 2016. Do you see any problem with that?
That is to be paid outside of closing. If it don't,
everything that I read. Do you see any issues with any of that?
Well, it should have been put in escrow, probably the way I would have read it up, to be put in there.
That's the only issue you see.
Well, it's that he's going to forfeit.
Says that buyer agrees to pay an additional $500 plus forfeit the earnest money of $500 already paid to Parrish and Associates in the event this transaction fails to successfully close on or before June 10th, 2016.
That was a part of the extension, I think.
It is, but
that was what the.
I would like to know what happens to that $500 and the other what happens to the two $500? What happens to it?
It goes when it's handed to Parrish. It will go to the seller.
Does it say that?
But it should be in there. I would say that it should definitely be in there. But that was probably an understood with all of us that that's where it would go. I don't know of anybody else that would be entitled to that earnest money.
Do you think it's clear?
Well, to me it would be clear, but maybe to anybody else it might not.
Mr. Douglas.
It could be communicated a little bit better, I guess. You can't say that.
Mr. Douglas.
Mr. McCormick, I just want to first say that I perceive you to be a very kind, conscientious man, and I have a question for you. Where is White House, Tennessee?
Well, I don't know if you can get there from here. No, it's not there.
Not that
You go up 65 north, and it's the 108 exit. And
How far is it? That's really
from
what I
down
wanna know.
here, I'm
He's
guessing
from
about-
Memphis.
I'm from Memphis, yes, sir.
I'm guessing it's probably 25 or 30 miles. I'm thinking.
Okay, all right. I didn't know if you traveled 2 or 3 hours to get here or not. My question is, I'm sure that you understand that there was a major faux pas here in the way this was written, and it caused some consternation on the part of a lot of people, including yourself.
Oh.
You'd rather not be here today, is that correct? And my
for
question
this
is,
occasion.
why, knowing that this mistake was made, why didn't you just pay the $1,000 fine and move forward? What is it that made you want to come and appeal this and hire counsel to come with you? What is it that made you want to do that, to make this appeal?
Well, I honestly felt, and I still feel, that this complaint was, that complaint this guy wrote, that he didn't tell the whole story. He didn't tell it right, I can tell you that. But he's accused me of running an illegal company. I've served on the grievance committee in our association. I have. I just don't. I don't think that. How can I be responsible for something I didn't know? I didn't know that he did not do this. Did not put a contingency in.
Let me give you just a follow-up question then, and I think there's no doubt in my mind that there was a mistake made, that maybe there. Well, let me just ask you: do you think that in the future that you may implement some policies that might prevent this mistake or this type of incident from occurring again? And what kind of policy?
If it happens in mine, they've got to be a complete fool to do this after what I've told them.
And what kind of policy will you implement to prevent, let's just say, this specific problem from happening again, where an agent fails? I know I saw the stipulations section on your checklist,
Yes,
but
I
there are a
know.
lot of different stipulations, and I understand that a principal broker can't monitor every single piece of verbiage that's in a contract. It would be a total impossibility to do that, and you have to, I think, put some trust in an agent's ability to write a contract. I agree with that 100%, but we know that this one's caused some major consternation. What type of policy will you implement in the future to make sure that agents, when they are looking at that stipulation section, they're thinking contingency?
Yeah, I put it here. I've given it in writing. I've done it. Down at the bottom, I put a reminder down there. All documents must have signatures and must be dated.
But in the future, apparently that one didn't get the job done. So in the future, is what I'm asking, what will you do to make sure to prevent a problem with this contingency issue in the future? Will that be something that you'll add to your list?
Yeah, you will no longer work here.
Okay. Okay. I just want to say this. I know that you probably feel like you've been run through the ringer today, and I don't believe, and I don't believe anyone on this panel believes that you're a common criminal. You're not here. You're not here. You're not getting ready to go to jail. And I'll be quite honest with you. I think I heard enough an hour ago to make a decision on this, and it's like scratching my fingernails on a chalkboard now. And I'd rather have a sharp stick poked in my eye than to continue this for another hour or 2 hours. Okay, I think in my opinion, we've heard enough. It's time to make a decision and go home. And I just want to say that I believe in my mind, and that's why I asked the question, that you've learned enough. This has been a very educational experience for you, and that you've probably learned enough to move forward and implement some policies to prevent this. Is that true?
You're right, and I'll say this about I didn't know that he was just from, and I think he's a very nervous guy, and I was hoping that he would answer the questions, maybe know the situation better, since it was his deal, and since I'd never had any problem with him before, and just in talking with him in general, I just thought he was a good guy and everything went fine. I don't perceive him as a greedy guy. And the reason I say this is he and his wife sat on the same pew in our church every Sunday, and he's done a lot of good things. He's helped us. I'm part of a community deal where that we take when the post office collects all the canned goods or whatever, they bring them to the post office, we take them to our community, to our city hall.
Sure.
And he helps with that. He's helped some of the, done a lot of things like that. And
Let me just say this, I'm going to turn it over to, I think, Marshall wants to ask Commissioner, other commissioners want to ask some more questions, but let me just say that one of the things that I've noticed is a lot of honesty today. Okay, there's not been fast talk, double speak. You guys have admitted where you were wrong, and I appreciate that very much. You know, we do have people come before this commission who are really good talkers, and they try to talk around, you know, rather than admitting they're wrong. I haven't perceived that to be the case here today, and I really think that's all I wanted to say, and I think we have enough information, in my opinion, to go ahead and make a decision. Thank you for being here.
Yeah, well, thank y'all guys. I know we really need. There's a lot I've dealt with, and all of you that are in the real estate business, I know you've run across a lot of stuff that you see that shouldn't be done, and I think we all do. And unfortunately, and people that try to do something where it's not right and not honest, and if you can't, you don't get any. It'll hurt you. It would.
Let me just say this too, and I know we're not here to make a decision on a complaint on another agent, but in my mind, Mr. Diedrich's agent has some culpability in this as well. You know, so don't know of any complaint that's been filed against him, but I think he also, you know, should have been monitoring this situation. He should have maybe asked after, you know, or maybe advised his agent, hey, you've got 4 or 5 other offers, maybe we better go with another one, you know, after the first amendment to the contract was made to extend. So there's culpability on all sides here. So.
But Diedrich, in his rage, told me he was going to sue him too, and he was going to sue the other agent for Patel, and he cussed her on the phone, and he was cussing Ray. That's a real. I think he lost his job, from what I have heard since then.
Okay, well, thank you very much.
Ms. Franks.
That's not why we're here.
Ms. Franks.
If you'll oblige me a moment or two.
I will.
You know, this whole thing to me, I agree that both of you seem that you're honorable men. You don't lie, you don't steal, you don't cheat. That's how I was brought up. And I'm a principal broker, and this pains me too. Because I have made mistakes too, and not everybody gets caught, you know. But it comes down to, as a member of this commission, the charge is failure to supervise. Now, it worries me a little bit, well, it worries me a lot, that you're maybe not seeing, because you had trust in this person, and I understand that too, you trusted this person that you didn't need to be seeing all of his paperwork. I think that was the thing where you went wrong. Had you been seeing all the paperwork, I don't think we'd be sitting here today. And to me, that does go to supervision. Do you scan and email yourself?
Myself?
Mm-hmm.
Do I scan stuff to myself?
Scan and email to your agents and whoever?
Yeah.
Okay. Yeah. I asked that. My husband doesn't know how to scan, so that's why I asked. But I think it's very important. I just now have a policy. I'm a small company too, 12 agents. I'm small enough, and I like being small because of the responsibility. I don't know how some people handle the responsibility of so many agents. But anything that's got a signature on it, they have to immediately scan and email that to me. So every day, I mean, I'm getting stuff at night too, you know, but I'll look at it because it's easier to look at it then than to wait the day before the closing and then you find the problem. To me, then that's too late. To me, I wouldn't have supervised them up to that point. Even though you're giving them classes and you think you've taught them, they have their own minds and you don't know what they're doing. We're not God, and we don't know what everybody's doing all the time. We can't know that. Our only our only help, and I think the state of Tennessee is correct in holding us to it, is that if we're going to be the principal broker, is that we have to supervise them as best we can. Now, there's some people that come in here, and I can see there's no way they could have known. I believe you didn't know.
I did not.
But I also believe that had you had some procedures in place where you were looking at the paperwork instead of the day before the closing, that maybe some of this could have been remedied. I'm very sorry that he didn't have the confidence in himself to come to you right off the bat, because I have missed things. I didn't even notice until she said it that the name was missing on here. And, you know, we get used to looking at these TAR forms, you know, and we know where the block boxes are we need to check. And I understand why you're saying you weren't looking for a contingency. There's a place for it to be on here, and it wasn't on here. You're helping me in my company. I can tell you that's one of the lines that I'm going to add to my checklist, contingencies. I don't have that on mine either. So I think you've just been caught in something that is, no one up here wants you to have to be here. Our hearts go out to you and to Mr. Hall too. But I just have to say, I think that is probably what fault that I see in you is that it is supervision, and we can just never do enough, evidently. I'm sorry.
Hey, I think I'm going to turn it back over to you, Judge Stovall.
Thank you. I don't think council has any more questions, do you? Thank you, Mr. McCormick. You can take a seat. Get the proof, Ms. Palmer. Rebuttal, Ms. Ryan. All right. Are we ready for closing argument?
Yes, Your Honor.
Do you have a proposed?
I do.
Or do you have any proposed findings, Ms. Palmer?
I do not.
All right. Members of the commission, would you like to take a very brief recess before we do closing arguments and deliberation, or are you ready to push on?
I need a break. Do you need a break?
She might need a break.
No. Warren says he'd like a break.
Okay, we'll take a 5-minute break. Thank you.
Hey, I'm glad Bobby wasn't here today.
Oh.
Got an argument with his dog or his wife or his, the spouse. And
Well, I get an argument with the spouse, but that's not what this is
I didn't think so. It isn't none of my business.
Who's going to do the finance?
Hey, we're on break.
Angry? What you got?
Uh-huh.
Oh, there's the chocolate.
You're right.
And I'll take her
That's
Reese's
me.
Tears.
Know what responsibility a principal broker has to oversee the activities of an affiliate. In this particular instance, the affiliate made a huge error, and he admits it. And that error caused problems, and he admits it. And there was a contingency that was not in the contract, and he admits that. You heard, though, that the contract, while reviewed by this respondent, the discussions weren't made about, well, are there any contingencies in this? And we know at some point there was a sale for the house of the person that was buying the property, and yet it didn't ring any bells. There was a checklist, but on the checklist it is stated for special stipulations. I suppose you could call those contingencies, but it's sort of ambiguous. But in the end, what happened was we had an affiliate who went forward with things they should not have done. They made ultimate amendments that weren't viewed in writing by this principal broker, and left out a contingency that whether or not when the seller knew about it, we're not sure. says at the time of the contingencies that at the time of the amendments, in any event, it caused a big problem. And the problem could have been perhaps avoided if discussions were made on this contract prior to that, if all amendments to the contract showing the extensions were discussed prior to that, if the reason for extending the contract was discussed prior to that, perhaps all of this could have been avoided. We all make mistakes. And leaving out a contingency, I can see where that could happen to anybody. But the issue is, what responsibility does the principal broker have when their affiliate makes those kinds of mistakes? What could have been avoided if the principal broker had done something? In this instance, there was nothing in place to show that here it is, we're going to go over it. Yes, I'm going to look at every document at a certain time. Yes, I'm going to look at the folder at a certain time. None of that was in place. Now, I realize the principal broker is not an employer. Principal broker is overseeing management, and the affiliates are independent contractors. I understand that. But there's still a responsibility to make sure that those affiliates are doing what they need to do to protect the rights and interests of the people they are dealing with. That is what we do as a real estate commission. We are protecting the rights and the interests of the public of Tennessee so that they are taken care of in a professional manner. And I suggest that in this case he failed, and that as a result I'm asking that he be assessed a civil penalty and be required to pay all the court costs in this matter.
Thank you. Palmer?
Thank you, Commissioners. I appreciate all of your time today, which I know was extensive. The charge against Mr. McCormick, of course, is failure to supervise. The question that we have had, and there was a question asked of Mr. McCormick, why did you appeal? Well, the reason, the question that we have and that Mr. McCormick has is what is really adequate supervision? And I think that we can differ on that. There's not a specific definition of adequate supervision in the statute. There aren't any specific rules that deal with any specific issues like contingencies must be noted here or must be noted there. Mr. McCormick relied upon his agent to fill out the checklist to put the contingency, if there was one, in the special stipulations. Now, I understand that perhaps in hindsight, relying upon him is something that he shouldn't have done. Clearly, the complaint, which accuses Mr. McCormick of doing this intentionally, I think is something that we can dispense of rather quickly. Clearly, it was a mistake. We acknowledge that. I think, though, that we have to look at the ambiguity in failure to supervise. How does a person know if someone doesn't tell them that there should be a contingency? Someone said, well, he was buying the house, he was selling the house, so that should have rung a bell. Well, a lot of people don't need to rely on selling one property to buy another property. It happens all the time. So I suggest it's not necessarily something that you would say, oh, there must be a contingency because he's selling a house as well. So I'm not so sure that that would have led Mr. McCormick to ask his agent whether there was a contingency. The other thing is, Mr. McCormick testified, look, I don't know what's in his heart. I believe it was a mistake. We all know that there are agents out there who will not put a contingency in a contract purposely because they want to get their offer in and get it jumped on. I don't know that happened or that didn't happen. But, I think based on what we've heard, that even if Mr. McCormick had asked, even if he'd said, well, wait a minute, there's a sale here too, is there a contingency on this? I think Mr. Hall would have said no. So I'm just not so sure that the evidence in this case, meets the burden of being substantial and material that he failed to correctly supervise. Is he supposed to go and speak to every single client and say, hey, is there anything in this contract that, is wrong? Is there anything not in here that you wanted in here? Clearly, that's not their responsibility, I would suggest. Mr. Dedrick was represented by an agent. He didn't catch it either. He didn't come back and say, wait a minute, you didn't put this in the contract once he realized it. Didn't ask any questions. So I don't think that Mr. McCormick, frankly, should be punished for relying on his agent. Mr. Hall is experienced. 10 transactions, I suggest to you, is more than enough for an agent who is trained, for an agent who has passed the exam, for an agent who's working in this business to know that he needs to put a contingency in the contract. I think that Mr. McCormick is entitled to rely upon his agent's independent judgment and his agent's professionalism. We can say, well, there should have been another procedure in place. And, respectfully, somebody here today on the distinguished panel has said, gee, I may start doing that as well. So I suggest to you that what he didn't do is not it's not so clearly a violation of his duty to supervise when we have another person saying, I better start doing that too. I suggest to you that he firmly believed that what he was doing was sufficient. He believed that and knew that his agent knew that he had to put down a contingency. Maybe he should have gone and looked at the amendments moving the closing, but he confirmed that there were some. I just think that, and Mr. Hall, of course, admits what he did, but I think that he retains the discretion and he retains the judgment, and I think he grossly failed in representing his client, and I'm just not sure that Mr. McCormick really had a way to know that. I think hindsight is 20/20. We can all sit here and say, well, gee, if you had done this, you might have known. If you had done that, you might have known. But respectfully, there's a good chance he wouldn't have, because there's a good chance that this agent wouldn't have been forthcoming because he was scared or whatever he was. So I think it's difficult to hold Mr. McCormick responsible for this situation in a circumstance like that, where we have someone who clearly knew what he was supposed to do and didn't do it. After having multiple opportunities to do it, he continually and repeatedly chose to hide this fact. So I'm just asking you to consider that. The other thing is, I just think in light of the standard that we have, or the lack of a standard, the lack of a kind of a clear list or clear guideline for what constitutes failure to supervise, these have to be looked at on a case-by-case basis. So I really think the facts should be taken into consideration, that Mr. Hall was so deceitful in this process. I guess I would just ask that the charge be dismissed would be our request, and if not, that the penalty take into consideration everything that you've heard today. Thank you very much.
Palmer, anything else, Ms. Ryan?
No, Your Honor.
All right. Would you have
Yes, and I do, and I have a correction to make on them. But
The
when
proposed
we pass
findings.
them out.
members of the? Oh, I'm sorry.
I just have proposed findings of facts and conclusions of law. Wait a minute. Wait.
Did you want to tell them what the correction is?
Yes. In the findings of
Why
facts.
don't you go ahead and pass that
Yes.
to them so they can see what you're looking at, or they can look at what you're referring to.
In the findings of facts, under while responsive, Mr. Hall's principal broker, the following acts transpired. I just want to be sure you understand that respondent in that meant is Hall, Respondent Hall, not this respondent. These are things that Mr. Hall did, except for number 4, respondent as principal broker. But so for B and C, it should be Hall did not advise all involved.
I'm confused. Will you say that again?
Sure. In fact, number 2, it says the agreement did not include the terms the sale was contingent on the sale of respondent's client's home. it's Mr. Hall's client's home. And number C, it says respondent did not advise, it's respondent Hall. Mr. Hall did not advise all involved that Hall had failed to include the contingency agreement.
So C or 3C should read, Mr. Hall
Right.
did not advise all involved that Mr. Hall
That's correct.
had failed to include.
And B should read, the agreement did not include terms that the sale was contingent on the sale of Mr. Hall's
client's home.
Right.
Okay. And also, I guess, in 3A,
That's correct. It should be Mr.
it
Hall.
should read, this
represented.
last sentence should read, in this agreement, Mr. Hall represented the buyers.
That's correct.
Okay. All right. Members of the commission, let me make a few very brief comments to you in the form of a charge, and then I'll allow you in a moment to review these proposed findings for you as you begin your deliberations. It's your responsibility at this time to make a decision in this matter. That decision will be the final order of this board. That order must contain findings of fact, conclusions of law, a determination as to what, if any, penalty is appropriate should you find any violations of your law, and then ultimately reasons for the decision. The burden of proof is on the department to prove by preponderance of the evidence that the factual allegations contained in the notice of charges are true, and also by that same preponderance of the evidence that the facts that you find have been established in this case constitute a violation of the law, the statutes, and/or rules as is set forth in your notice of charges. I might direct you the proposed findings that Ms. Ryan has presented to you are not to be considered as evidence in this case, obviously, nor are the notice of hearing and charges. That is not evidence either, unlike the exhibits that have been entered into the record. However, you might wish to use these two documents as a guide during the course of your deliberations. When you make your findings of fact, you need to make specific findings as to the factual allegations set forth in these two documents, and I would suggest to the board that the facts in this case really are not in dispute. And I think that the crux of the matter is the conclusions of law in the Ms. Ryan has set forth in the notice of both in the notice of hearing and charges as well as her proposed findings the violations of statutes and rules that are at issue in this case. The specific statutory provision at issue in this case is one that we have discussed today. It's 6213.312B15, which is in the case of a licensee failing to exercise adequate supervision over the activities of any licensed affiliate brokers within the scope of this chapter. Should you find that by preponderance of the evidence that the respondent, Mr. McCormick, has violated this provision of your statute, then you are authorized to impose a disciplinary action. What, if any, discipline to impose should you find a violation is completely at the discretion of this board. The Ms. Ryan, the department, has recommended to you that you find that you impose civil penalties in this case. The civil penalty, you are authorized by statute and rules to assess civil penalties. The range of civil penalty for a violation of that statutory provision is $250 to $1,000. Ms. Ryan has also requested the assessment of the investigatory and hearing costs of this proceeding should you find that Mr. McCormick has violated the statute. You are authorized by law to assess those costs should you deem that appropriate. After you make your decision as to what, if any, discipline is to be imposed, you then must state the reasons for your decision. As I stated at the beginning of this hearing, I will not participate in the decision that's made on the merits. That decision is to be made by the commissioners. However, I will be available for any questions that you might have of me during the course of your deliberations. And if I don't have any questions at this time, I will turn it over to Mr. McMullen to conduct the deliberations.
Thank you, Judge. So at this time, we have to consider proposed findings of fact, and there are a number here that have been proposed by the state, and as Judge Stovall said, the facts mostly are not really in dispute. Is there a motion to adopt the findings of fact that were presented as revised in a couple of parts that were presented by Ms. Ryan?
I'll make that motion.
Okay. All right, we have a motion by Commissioner Bloom and seconded by Commissioner Taylor to accept the findings of fact that were proposed as slightly revised with a couple of words. Any discussion on those facts? All right, hearing none, let's vote. Do we need to take a roll call vote, or is a voice vote enough?
Voice vote.
Okay. All those in favor of adopting these proposed findings of fact, say aye.
Aye.
All opposed, say no.
No.
Okay. That motion carries 6 in favor and 1 against, with Mr. Douglas voting against. Are there any additional facts that anyone believes should be added to our findings of fact?
Not sure if this is an appropriate addition or not, but I think it's a statement of fact that there was no listing agreement in place for Mr. McCormick to review and therefore make the connection between the purchase and sale agreement and the contingency that should have maybe been included in it. At the time, there was no listing agreement for him to make that connection.
Okay. So you want to make a motion? That's your motion then, to adopt that as an additional finding of fact?
Yes, sir.
Okay. Is there a second?
Second.
Okay. We have a motion by Commissioner Douglas and seconded by Commissioner Franks for additional finding of fact that there was no listing agreement in place from which Mr. McCormick could have determined that his firm was representing Mr. Walker in both a selling and buying capacity. Is that basically what
That
you...
sounds better than
yeah.
mine. Yes.
Is that what you were saying?
A question, did you mean copy or copy available? Because I'm not sure that I was clear as to whether there was an agreement or not. Maybe a copy available?
Well, it's my understanding after the questioning that there was no listing at the time the purchase and sale agreement was done. He was buying a new home, got under contract on that one, and then he decided to list the other property. So there was no way he could have made that connection in reviewing the purchase and sale agreement.
All right.
Mr. Horn.
I got a question. Who construct the list of what the guide should go by? I know they've been to school and all of this, but is there a list posted somewhere saying that the principal broker should check for the following? And if you're sort of arbitrary on this thing, you can almost put anything down there that you want. So I'm wondering, are we offering the proper guidance to those who look to us to set the standards?
Well, go ahead, Mr. Bloom.
Well, there's one offered by the Tennessee Association of Realtors. I know not every person's a member of the Tennessee Association of Realtors, but there is one offered. When they have all the different forms, one of the forms is this checklist.
But if it's not equally available to everybody, we live in the United States, and the poorest to the richest guy might not have internet. Should be able to get that list.
So the motion that we have right in front of us right now is Commissioner Douglas's motion, which has to do with whether there was a listing agreement in place. And so let's talk about that and see if we're ready to vote on that, or is there additional discussion on that particular subject. My understanding of the testimony was that when Mr. Walker came in on April the 12th, he signed both an exclusive buyer's representation agreement and a listing agreement. Now, I think that Mr. Hall didn't actually list Mr. Walker's property for sale until after the 15th, but my understanding from what Mr. Hall said was that when Mr. Walker came in, he signed both of those agreements at that time. Was that
was my understanding, because when I questioned, I had thought from earlier statements by the attorney I had it right, but then when I questioned Mr. Hall, I thought, boy, I got that wrong, and you clarified that with your questioning, which I appreciated, and that's how I interpreted the answer. So that's why I questioned, should it be copy? So.
He did not have a listing agreement at all when he wrote the offer on the house. 4 days later, he had a listing.
So is there, just to make kind of a fine point of it, the difference between a listing and a listing agreement? So I thought that when Mr. Walker came in on the 12th, he signed a listing agreement and an exclusive buyer representation agreement, but that Mr. Hall didn't get around to actually listing the property on MLS until a few days after the 15th.
Because he was asking, so we had a buyer's agreement here in front of us. We don't have a copy of the listing agreement. Yeah. When did you do it? And he said at the same time.
I'm guessing it would be, I couldn't make a statement of fact then until we had clarification on that. Was there a listing agreement and an exclusive buyer's agreement, both signed at the same time?
So my interpretation was that maybe the broker did not have a copy of that. That's what I had thought.
I guess my interpretation was that the buyer wanted to see some properties first to see what was out there. They found one, they put it under contract, and then he, in a hurry, decided now we need to get your property listed and get it sold to make this work.
Mm-hmm. Okay, I see what you're saying.
And that listing was signed 4 days later.
That's correct. That was my understanding.
That was my interpretation. So I guess we just have to have a vote on what the interpretation was.
Yeah. So any other discussion on this particular point? All right. Hearing none. So if you vote yes, then you're agreeing with the motion that...
Under the circumstances, Mr. McMullen, since I think we're going to have a divided vote here, I think I'd do a roll call.
Okay. So we'll take a roll call here in just a second, just so everybody's clear what they're voting on. We're voting on the motion, which is to say that there was not a listing agreement in place before April the 15th. And so if you agree that those are the facts that we heard, then you'll vote yes. And if you disagree that those are the facts that we heard, then you'll vote no. Ms. Maxwell, could you call the roll, please?
Commissioner Horn?
Yes.
Commissioner Taylor?
Yes.
Commissioner Bloom?
Yes.
Commissioner Hills?
No.
Commissioner McMullen?
No.
Commissioner Franks?
Yes.
Commissioner Douglas?
Yes.
Thank you. That motion passes 5-2 with Commissioners McMullen and Hills voting no. Are there additional facts that anybody thinks we need to make a finding about? Anything else?
Well,
another one?
I don't know if this is appropriate either, but is it appropriate to say that there certainly is a great deal of ambiguity with regard to what supervision or the definition of supervision within the statute?
That may be more of a conclusion of law than a finding of fact, I would think. And I'd submit it to Judge Stovall. Yeah. Mr. Horn.
Yes, sir. I need to back up here on this last one y'all just did. I'm not sure what I voted on.
Okay. What are you thinking that you voted on?
Well, I don't know. I thought the way you said if you disagree with the finding, you vote yes, and if you agree with it, you vote no. And we went backward. So where are we on this?
Yeah, so the question we were talking about was Commissioner Douglas's motion, and that was to make a finding that there was no listing agreement in place on April the 15th. Is that,
That's
just
correct,
to
yes, sir.
summarize it as quickly as possible. So we were making a finding that there was no listing agreement in place. Now, I understand it may have been a little bit confusing to say that if you agree that there was no listing agreement in place, then you'll vote yes.
Okay.
But if you disagree with that, then you would vote no.
Okay, so
And so the yeses had that 5-2, and you were one of the yes votes on that. Are you still okay with that? Does that help?
what I was hoping I was doing.
Okay, then it sounds like you agree with what you did then. Okay. All right. Any additional findings of fact that anybody thinks we ought to make? Okay. If not, then we will proceed to conclusions of law. And so really the question I think we have in front of us is, do the facts that we've approved constitute a finding that there was a failure to exercise adequate supervision over an affiliate broker under TCA 62-13-312B-15? So at this time, I would entertain a motion one way or the other on that, whether you think those facts constitute a violation or not. And I'm going to turn the floor to Commissioner Taylor. Pull that down if you don't mind and speak.
I make the motion that we find the defendant guilty of Tennessee Code 62-13-312B-15.
Okay. You've heard the motion. Is there a second?
Second.
All right, we have a second by Commissioner Hills to find that there was a violation of the failure to supervise section of the code. Discussion.
Yes.
Mr. Bloom.
Well, yes, I think the failure to supervise, as it's stated in our manual, is nebulous enough that the net caught Mr. McCormick. But I don't think that he is guilty of not supervising someone who hides his files. I don't know how you could supervise someone who didn't want to be supervised, so I would vote against that.
Okay. Additional discussion. Anybody want to say anything?
Well, I think
Miss Taylor.
I think it's I disagree. I think that he is guilty because once even the files were brought to him and he looked over them, he took no action on the inaccuracies in the files that he was brought. So I would say that when in conversation with the agent, Mr. Hall, knowing that he didn't have a lot of the information and asking him to bring it in, he still did no follow-up to see that it was in. So I think there's clear lack of supervision.
Mr. Horn.
Yes, sir. I'm having trouble, and I'll tell you why. For some reason that I would have to say in my heart, yeah, it was violated. Okay, but the idea again, was it something that was intentional? Was it something that we need to put our thumb on? Is it something going to go out to agents brokers everywhere? But I should save this until the punishment phase if we get that far. That I would say that any punishment should be suspended in conjunction with the troubles it's already caused him. And I thought he was very specific when he came out and said, this thing has almost ruined my company. It's almost ruined me. And I don't think we could do much more punishment. It takes the money off of him. But anyway, let's go ahead with the facts, whatever you're going to do. And but that's the way I'm thinking. I don't think he should be punished anymore. Whether we should go ahead on with finding facts, I don't know.
All right, Ms. Franks.
Mr. Horn, if he is found guilty of these charges, we have in our latitude of $250 to $1,000. So I'll just go ahead and say I would be for the least amount we could give him on that if we find him guilty of lack of supervision. It's a hard thing because I don't think any of us really want to find him guilty, but then the facts are facts. And I just wanted you to know that we do have that leeway, that we can make it a lesser amount than piling on him.
I thank you for your advice, but however, like I say, I'll stick with what we've said.
All right, so the motion we have in front of us is Commissioner Taylor's motion to find that there has been a violation of the failure to supervise section of the statute. Is there additional discussion on this question? Commissioner Douglas.
I did have one additional, please, sir.
Okay.
I know that we have the latitude $250 to $1,000, but do we also have the latitude just to issue a warning?
Do we?
Can we ask for legal advice on that?
Yes, you don't. You can, assuming for sake of discussion that you find a violation of the law, you can impose whatever sanction is you deem appropriate, or no sanction. So you could, a letter of reprimand, the minimum civil penalty, no civil penalty and assessment of costs, civil penalty with no costs. It's completely at your discretion.
Thank you, sir.
All right. Additional discussion on the motion. All right. Hearing none, why don't we have another roll call vote? And if you agree that there has been a violation, you'll vote yes. And if you disagree and don't think there was a violation, you'll vote no. Ms. Maxwell.
Commissioner Horn?
Yes.
Commissioner Taylor? Yes. Commissioner Bloom?
No.
Commissioner Hills?
Yes.
Commissioner McMullen?
No.
Commissioner Franks?
No.
Commissioner Douglas?
No.
So that's 4-3, no.
Okay. So at this point, that was the only charged violation, and the vote was 4-3 against a finding of a violation. So, Judge Stovall, what action do we take at this point?
I would assume, Mr. McMullen, actually there were two allegations, but really the first allegation is really tied to the second. The first allegation was the general provision that he is violating any provision of this chapter, and so I don't think you could find that he violated a provision of the chapter if you didn't find the specific. So I think if the vote is 4-3 that you find no violation, that you therefore find no violations and dismiss the action.
I think that's been the result of what we've done today. So do we need to take any additional votes on that, or is
I don't
that where
think
we are?
so. Well, yeah, you might want to just make a motion
to
that effect. And also then I think, especially in this case, it might be appropriate for you to articulate the reasons for your decision.
Okay. So at this point, the chair would entertain a motion to dismiss the charges against Mr. McCormick.
Charges against Mr. McCormick.
Okay, the motion by Mr. Horn, seconded by Ms. Franks. Any additional discussion on that? All in favor will vote aye.
Aye.
All opposed will vote no. That motion carries. And so would anyone like to make a policy statement that would explain the reason for what we did? Mr. Douglas, do you want to take a shot at that?
Well, you're so much better at it than
Well,
I am.
But you're a preacher.
Yeah, could you take a shot at it?
Give me some guidance on making the policy statement.
Well, I guess it would have something to do with, the obligation to supervise, but what can you supervise without information, possibly? That seemed to be where a lot of the discussion was going.
All right, you can maybe help me out here. As a policy statement that licensee may be engaged only as a principal broker who is engaged primarily in real estate and who is accessible during normal working hours to the affiliates. And when we're making a policy statement, am I making? I don't want to go back to making statements of fact again, right?
You could talk about how the facts here may have played into some of the policies that we have in place, if those really resonated with you.
That Mr. McCormick was primarily engaged in the real estate business, and he was accessible during normal working hours, and that Mr. McCormick did not have the opportunity to review documents and make the connection between the purchase and sale agreement and that's good. Because he had no knowledge of a future listing agreement that would have allowed him or enabled him to make that connection.
Okay.
I don't know. That sounds like a long policy statement that you need to hone
You've
down.
heard the motion. Is there a second?
Second.
All right. Any additional discussion on the policy statement? Mr. Horde.
As most of you know, I'm a pastor. A choir member to smack another one. Okay?
I want to go to his church.
You can't hold me responsible for that. I guess you could. Deep down, I am in charge of the whole congregation. And I felt so bad when that happened. And I feel for you. I felt there was nothing I could do. And I see the same thing happening over again. Somebody in your choir smacked somebody else, smacked you too. And but will we hold you responsible for it? So anyway, what I'm saying, I agree with that statement that you're making, and I'll stand by it 100%.
All right. Any additional discussion? Let's vote. All those in favor of adopting the policy statement will vote aye.
Aye.
All opposed will vote no. That motion carries unanimously. Judge Stovall?
Further, we'll stand adjourned. Thank you very much.
Thank you.
Thank you.
And I believe that concludes our meeting for the month, unless there's any other action that any commissioner would like for us to take or any statements that anybody would like to make. All right. The TREC will stand in adjournment until next month. Thank you.
You carry into that stuff, don't you? So you did a good job. You carried into that stuff, don't you?
That's a hard one. That's the devil in the details right there.
A lot of these things.
I think there was too, but everybody disagreed with me. And so that was what ended up changing
I could
my
always
mind, even
learn
though I
more.
thought that was what I heard.